Apply. This matter may listed for orders. Now, in this case, notice of motion was issued in September 2022, and for 6 weeks, it has not been listed. My lord.
You put the date of 15th March.
My lord.
Yes.
Maybe also. The petition was filed on 23/2, my lord. Matter pertaining to suspension, my lord. Friday, my lord.
All right.
Then one matter, my lord, it was last listed on 7/3/2021, my lord. Matter selection
15th March.
May it please, my lord. My lord, item number 58 of supplementary list, my lord. We are supposed to file rejoinder affidavit and my lord objection in the IA, my lord. And I am praying for 2 weeks time, my lord, since the petitioner he is posted in Delhi presently, my lord.
My lord, date may be fixed because stay order is because one post has been vacated, still vacated.
17th March. 17th March.
17th March.
At the request of Mr. H. Chaudhary, land counsel for the petitioner made with the applicant, writ petitioner made with the consent of the other side. This matter stands adjourned till 17/3/2023. List accordingly.
My lord, in item number 19, we have filed affidavit in opposition. My lord, that will be called for.
My lord, I am paying for listing this matter for withdrawal, lordship, on Friday, lordship.
All right.
All right.
May it please, your lordship. I wish to mention an old pending matter, my lord. Old pending matter since 2014, my lord. My lord, for listing.
You approach the registry and then come back.
May it please, your lordship.
My lord, earlier I have mentioned, your lordship has allowed.
You
but-
do it once again and we'll see.
May it please, your lordship. I beg to mention for a listing of matter WPC 7688 of 2015.
Go, make a request before the registry. If they don't do it, you come back. Make an application, list this matter. Yes, next
Yes.
matter.
My lord, pencil matter, my lord. List on
17th March. 17th March.
Your lordship, this matter, it was last listed on 25th, 1 of 2023. So I pray for.
See, I don't do the listing. I only allow mentions if urgent order is required. You have
Yes.
to understand that.
Lordship, this matter pertains to an urgency.
All right.
This matter has been pending since 2015, your lordship.
You make a request to the register and then if he doesn't do it, you come back. We'll have it. Okay? Yes.
May it please, Mr. Lordship. I'd like to mention for the listing of a matter for orders, the matter pertains to order of termination from service of the petitioner without giving him the opportunity of being heard.
17th March. 17th March.
Much obliged.
Phone consolidation.
My lord, earlier, my lord, this honorable court asked for produce some petition, your lordship. Already I have annexed with this petition, your lordship. And there are 2 citations. One is your lordship, 2006 9 SCC and 195, your lordship, and 2027.
What citation? What is your matter?
Yes, my lord. This is a case of compassionate ground case, your lordship. But first time I was rejected for under AS, your lordship. Thereafter, I have appeared this honorable court, my lord. Thereafter, one order, I was allowed to recommend this case, my lordship. For confidence.
Where is the division bench order?
Yes, my lord. There is order, page number, your lordship, 36, your lordship. Yes, my lord. Last paragraph, last, your lordship, page number 38. Paragraph 10, your lordship. Paragraph 6 also, my lord, already discussed about the matter. My lord.
Yes, what is your stand?
Lordship, delay.
Huh?
Delay, your lordship.
Delay.
Delay. Because the whole purpose of
Is there any judgment?
there is a judgment of almost Supreme Court, state of Rajauddin, state of Manipur versus Rajauddin. It's 2003 7 SEC 511.
Where is it?
I have sent it to email, to the email.
Then we'll give our response to email.
No, your lordship, I just actually I didn't have a copy, but my lord, this case already covered this case, your lordship. Page number 67, your lordship. Please kindly come on this case. Syed Khadim Hussain versus State of Bihar and others, your lordship. 2006 9 SSC. Already I have produced this order, judgment, your lordship. So my lord, fully this order covered my case, your lordship. So my lord,
No, what is the policy of the state?
State otherwise, because 2 years has elapsed as per the judgment, earlier judgment. Now 2 years has elapsed and that's why now,
Where is it? Has somebody phoned you up and told you, or is there anything in writing?
no, your lordship, otherwise I don't have it right now that 1/6/2015.
Then will issue notice. Yes, Mr.
as Islam, your
As
Yes.
Islam Lawyer Counsel for the petitioner, there is the amendments made in the writ petition. The petitioner is aggrieved by rejection of his application for appointment on compassionate ground. Mr. D. Bora, learned government advocate Assam submits that the decision the prayer made in this writ petition is barred by time. However, the learned government advocate Assam could not substantiate his argument with any authority. Full stop. On the other hand, Mr. Islam has relied upon the decision in the case of Syed Khadim Hussain versus State of Bihar, represented in 2006 bracket close 9 SCC 195, to submit that the application submitted by the petitioner could not have been rejected because he was a minor on the date on which his father had died. First up. In view of the above, this matter would call for further examination. Issue notice of motion returnable in 6 weeks. Since Mr. Bora has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ will be furnished in the Department of Counsel.
I can too.
Wait, please. So the pursuant to a recruitment process, my lord, an advertisement, my lord, the petitioner was selected to the post of junior engineering assistant in the respondent corporation, my lord. My lord, that was on 31/12/21, my lord. They had joined the services. Then out of the blue, my lord, a termination notice was issued, which your lordship
Where
finds
is
at
it?
page 40.
Page?
Page 40. Okay. No forewarning, no show cause, nothing. my lord. Page 40. My lord, will mark an internal inquiry was purportedly held, which your lordship finds at paragraph 2, my lord. Behind my back, and 1 year, 2 months later, I've been served a termination on the ground that there was some anomaly, alleged anomaly in the recruitment process, my lord. What is also pertinent, if your
What is the anomaly? What is the anomaly?
my lord, that is not specified, my lord. It says, since you have been erroneously selected. Even, in fact, there were 2 complaints before the vigilance, which have also not been served upon me. Absolutely no.
You are appearing.
My lord,
I appear for IOC.
If
Yes.
your lordship comes to the order of appointment, which your lordship will find at page 34. And if your lordship comes to page 35, clause 3 there. You shall be on probation for a period of 6 months from the date you join the post, which may be extended or reduced depending upon your performance, application, etc., etc. If your work is found to be satisfactory during the probation period and verification of your caste, etc., character and antecedents are also found satisfactory, you may be confirmed in service. Your services will not be regarded as confirmed until a letter of confirmation is issued by the management. Your services can, however, be terminated at any time during the probation period without notice or assigning any reason thereof. There were certain complaints. We conducted a preliminary inquiry, an internal inquiry, and there certain things have come out. We didn't want to, your lordship is aware of the law, we didn't want to attach any stigma or anything. We have issued an order of termination simplicity. And that is how it stands. The law is very clear on the subject.
That West Bengal decision.
Several, right from Purushottam Lal Dhingra.
No, that's all right. But the point is, if you say that On completion of probation period, his services were not found satisfactory and he was discharged. Then in that case, we may agree with you that no further notice is required. But the order of termination says otherwise, that there was an inquiry or appointment was made.
Your lordship is aware, right? So in Radhesham Gupta, Supreme Court has made the position very clear that if we find something, we are entitled to conduct a preliminary inquiry. And based on that preliminary inquiry, if there are some prima facie materials, we need not go into a full-fledged inquiry where notice might be required.
Chaudhary,
Yes.
what I'm asking you is, this is not regarding his performance as a probationer. This is regarding his appointment itself being erroneous.
Yes,
What is the error?
there are materials that have come up.
What is that material?
There are manipulation in marks.
Who has done it?
In certain cases, in fact, the officers who have been found to be prima facie responsible,
Hmm.
action is being initiated against them also.
Hmm.
Because based on the preliminary inquiry, the matter was referred to the CVC. CVC has made recommendations saying that you need to proceed with the officer, your own officers also.
Hmm.
That process is also underway.
Why don't you issue a notice and terminate?
The problem there will be, your lordship is aware of the law. If we keep it simpliciter, we need not give him a notice because he is in probation.
No, Mr. Chaudhary, please understand the question made. Perhaps you are understanding. You are entitled to discharge him. That is a order of discharge.
Mal.
Probation period not extended, neither confirmed. But the allegation in the order of termination is not that. It says your entry into the service itself is erroneous. What is the meaning of erroneous? There is nothing has been indicated. What is the error? Was there any malpractice? If so, who has done it? In what manner?
All those prima facie materials, we can place it on record by way of an affidavit. That is not the problem at all.
Hmm.
But as I was indicating to your lordship, if your lordship just allows me to place one judgment on the issue.
Hmm.
Ek minute here to guess. Om Prakash month, 2006-7. Back to Luna, in fact, this is a case where there was a disciplinary proceeding initiated. Proceedings were conducted, thereafter terminated. The apex court has said that that was not even necessary because he is on probation. 5-5. The citation is, my lord, the case is Om Prakash Man, 2006, volume 7, SCC 558. I am just placing the. Your lordship will excuse me for the marking. And in Radhesham Gupta, Supreme Court has and for the purpose of motion, my lord, your lordship has noted the terminations have already taken effect. So your lordship will examine the larger issue. In my irrespective submission, there cannot be any question of any interim order.
No, we may not like to stay the order of termination, but you cannot fill up that post
That is
held by him until further orders.
That
That we'll see. All right.
your lordship will.
All right. Heard Mr. B. We are passing that order. Let them file.
That is
affidavit.
my prayer.
Yes. Heard Mr. B.D. Dekkal and counsel appearing for the writ petitioner assailing the order of termination dated 17/2/2023 issued by the who has issued this order? Disciplinary authority.
The respondent number 4.
Respondent number 4, this writ petition has been filed. Mr. Dekkal submits that the petitioner was appointed in the post of
Junior engineering assistant.
junior engineering assistant dash Roman 4 bracket PNU bracket close. Pursuant whereto he had joined in service on 31/12/2021. However, by the impugn order of termination dated 17/2/2023, the petitioner has been terminated. The services of the petitioner have been terminated without issuing any show cause notice or giving any opportunity of being heard to him, full stop. Hence this petition, full stop. Mr. I. Chaudhary, Learned Senior Counsel assisted by
Mr. Maharia.
Mr.
Maharia.
Meheria. has appeared on behalf of the respondents and submits that since the petitioner was on probation, the question of issuing any show cause notice to him did not arise in the eye of law. In support of his above contention, Mr. Chaudhary has relied upon the decision rendered in the case of Om Prakash Man versus Director of Education, bracket basic, bracket close, and others reported in 2006, bracket close, 7 SCC 558, full stop. A perusal of the impugned order dated 17/2/2023 goes to show that pursuant to an internal inquiry and recommendation of the Central Vigilance Commission, it was found that the petitioner was selected appointed erroneously and hence the order of termination. Full stop. It is, however, not disclosed as to what was the error in his appointment or the anomaly in the selection process, and if so, who are the officials responsible for the same. It is also not clear as to whether any action has been initiated by the respondents against those officials. Full stop. Be that as it may, since Mr. Chaudhary, learned senior counsel for the respondents, has submitted that the facts will be placed on record in the form of an affidavit, the matter would call for further examination. Stop. Issue notice of motion returnable in any date. Would you like to choose a date? Anything after you? 20th of or 21st of April?
My lord.
21st of April 2023. Since Mr. So-and-so has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned counsel for the respondents so as to enable him to obtain instruction and file affidavit. First of heard on the prayer of interim relief. Stop. The said prayer will be considered on the returnable date. First of, however, as an ad interim measure, it is hereby provided that the post held by the petitioner shall not be filled up without obtaining the leave of this court.
My lord, there are two writ petitions where his selection and appointment itself is under challenge. Those may be tagged along with this.
Yes, yes.
WPC number 1373 of 22 and 8082 of 22.
Registered to list this case along with WPC number. Got the numbers name? You got the numbers?
1373 and 8082, both of 22.
So other matters.
My lord, 3, 4, 6, 7, and 8. In between, item 5 is something else. 3, 4, 6, 7, and 8 will be similar orders.
Same order,
Yes.
same date of termination, same post.
Everything same. No, posts are
Posts are different. I'll give the list.
I'll give the list. Post get up what I did. 3, 4, 6,
7 and 8.
Same order. Yes. List together. All right. Yes.
Obliged.
Mr. Chaudhary, the book will be available to you later. Yes. next
Deeply
one.
obliged.
May it please your lordship. So in the year 2008, lordship, petitioners were appointed as sub-inspector UB, Anam branch lordship. Thereafter, they undergone training lordship, and in 2011, lordship, selected merit list prepared, and ultimately the selection board confirmed the services of the petitioners lordship. And ultimately, in the year 2021, lordship, the petitioners have been promoted to the post of inspector. Now, grievance of the petitioner is that the sub-inspector AB, Arm branch lordship, who were appointed in the year 2010, they have been promoted lordship without the service confirmation lordship. The rule
We'll have to
39
issue
says,
notice yet.
lordship, now my difficulty is that lordship, the process has been initiated to promote the next higher post of in respect of the sub-inspector Arm branch lordship. In fact, lordship, inspector Arm branch lordship. In fact, they were appointed in the year 2010 without being confirmation. They were lordship promoted to the post of
So they are
inspector.
parties, they are made parties.
They have not, because gradation list I have annexed lordship in respect of the sub-inspector, inspector AB, who were promoted in the year 2018. Now lordship basically not to finalize the process in respect of the inspector who were promoted in the year 2018, not all lordship, because this merit list, lordship may kindly see annexer. No.
Promotion to which post?
Deputy DSP lordship. Yes. Annexer 7 lordship. So for my petition is concerned, page 89. For a moment, kindly see page 89. This is the final gradation list in respect of Inspector AB. AB is Arm branch. Now 89, lordship may kindly see in column number 10. These are the persons, they have been ABI, that is Armed Branch Inspector. They have been promoted in the year 2018.
Where is 89? I don't find any.
Page
89.
page 89, Lord, please. Tell me. 89. This is a part of the,
Just call Urup Vaishnav once. Urup Vaishnav.
is a part of the final graduation list in respect of the Inspector Armed Branch Lordship. Okay. Page 89, it starts from page annexure 7, page 83. But I am concerned with the page 89. These are the persons who were promoted to the post of Inspector AB in the year 2018.
And your clients were promoted?
In 2021, although we have been appointed in 2008, Lordship. And without being confirmed, in respect of Sub-Inspector AB, Armed Branch, without being confirmation, Lordship, they have been promoted. But in respect of the Sub-Inspector of Armed Branch, UB, Unarmed Branch Lordship, we have been promoted after confirmation. But Rule 39 said we should, the inspector should be confirmation, first service
So this
confirmation.
Inspector Armed Branches,
Yes.
who are your rivals,
Yes, Lordship.
they were promoted to the post of Inspector.
In the
Armed
year
Branches in the year
2018.
2018.
18.
You say that they were promoted before their services were
Yes,
confirmed as
yes,
sub-inspector.
Yes, Lordship.
So have you challenged that order?
Look, I have not. We are seeking also at par, Lordship, because
Can't be done unless you challenge, question that promotion. That is valid. And you came in 2021.
I have challenged a particular office memorandum, Lordship, in compliance of that particular office memorandum, Lordship. This sub-inspector AB, they have been
No,
promoted.
Mr. Deka, please understand. We are all students of law, is it not? We
Lord.
have to go by law, not by emotion.
Lordship.
According to you, these inspectors of armed branches who were promoted to that post in the year 2018,
21.
there is, no, the respondents, the other side,
Yes, Lord.
they are junior to you
Yes.
because
Admittedly,
their,
they have to take.
yes, because their promotion was not regular. They should have been first confirmed in the post
Yes,
and then promoted,
Lordship.
right? So if your argument is to be accepted, then the court will have to say that their promotion was not regular. Is it not?
Lordship.
Have you raised that question? Have you sought that relief?
Lordship, we have sought relief, Lordship, to consider.
If
our
you have
case
not
with
sought
the
that
at
relief,
par-
I am not going to pass any
At
interim.
par with, Lordship, at par with
Yeah.
the AB, Lordship.
Is it come?
Lordship, is the prayer portion. 40.
Mr. Deka,
Seven.
you should probably spend some time and apply your mind.
Promotional benefit of inspector.
Just 1 minute. It will matter, Sakshi. Opposition petitioner আছে। Yeah, আপনি এখানে হচ্ছে কিন্তু রিপিটিশন স্টার্টে না হয়।
To direct the concerned respondent authority grant promotional benefit of inspector UV with effect from 24/10/18 as it is done in respect of inspector AB, Lordship. And to that effect, we file representation also. that
Mr.
it can-
Deka, find some time during the course of the day and talk to Mr. Das. He will tell you what is the problem in your petition. I am saying this because I feel for your clients. We can always write a judgment just now. You better reflect on what you are asking for. You make that proper challenge and make that prayer. You say that 2018 people could not have been promoted. Their promotion was wrong.
Yes,
So
without being-
even though we came in 2021, you give us priority over them in terms of promotion, but you do not challenge their promotion in 2018. How is the REIT court going to entertain that kind of a plea? What do you want to do?
After a week, Lordship.
After a week, all right. Mr. Das, wisdom has prevailed. Yeah. Apply your mind, put in some effort because passing orders is not difficult for us, but we don't want litigants to suffer for technical issues. Yes. On the prayer of Mr. Deka, this matter stands adjourned for a week. Please take order.
Okay.
Mr. D. Boral, Government Advocate Assam is present on behalf of the state. Examine the issue. If you are convinced that this is okay, argue. then you argue. If you think some changes are required, accept it and do it.
Lordship, can it be on 10th of March?
After a week will be 10th only. Yes.
Probably.
Yes. Yes. What is the matter?
Well, here the petitioners are working as contractual employees under the APBCL. The limited prayer in this petition, my lord, is that they are seeking,
Seeking regularization. Regularization in service.
they were appointed
See, what is the relief you are seeking?
regularization.
Then I am issuing notice.
My lord.
I am issuing notice, or you want the court to deliver a judgment today?
No, I'm relying on the,
I am issuing notice.
My lord.
After that you argue. They want regularization more than 10 years. Heard Mr. P.K. Muni, Learned Counsel for the. Mr. Muni, time is a problem. You have to be to the point, crisp, precise. We work till 11 o'clock, 12 o'clock at night. We don't have time for repetitive things. You have to come prepared. Mr. P.K. Muni, Learned Counsel for the petitioner, also heard Mr. B. Chaudhary, Learned Standing Counsel, APDCL, also. APDCL, as well as Mr. H. Chakravarti, Learned Government Advocate, Assam, appearing for state. Mr. The read petitioners herein claim to have rendered more than 10 years of continuous service as meter readers and bill clerks. First up, aggrieved by non-consideration of their case for regularization, the instant read petition has been filed. First up, Mr. Munir submits that similarly situated meter reader and bill clerks have already been regularized. First up, Mr. Chaudhary, however, seeks some time to obtain instruction and file affidavit. There are annoyed 6 weeks since Mr. B. Chaudhary has appeared and accepted notice. Since Mr. H. Chakravarti, Learned Government Advocate, Assam for 1, and Mr. Chaudhary for 2 to 5, no formal notice, extra copies. List accordingly. Yes. Yes, please. Who is appearing?
May I please give a fee? Matter may be possible for the time being.
Let me pass over time being. This is compassionate appointment. After how many years?
Yes.
What is your instruction? Do you have any instruction?
No, test case, lordship,
Will issue notice then. Heard, Mr.
SM Jinnah.
Huh?
SM Jinnah.
What is this? SM
Jinnah.
Jindra. Then counsel for the petitioner. This matter relates to claim for appointment on compassionate ground. Mr. H. Chakravarti, Learned Government Advocate, Assam face for some time to obtain instruction. NIM 6 weeks since Mr. Chakravarti has appeared and accepted.
2 and 4.
For a
2 and 4.
2 and 4, and Mr.
1 is Pegu.
R. Pegu,
G Pegu.
G. Pegu, for respond numbers
1, 3 and
1,
Five,
3,
my
and 5.
Yes.
No formal notice, expect of this. Yes.
Lordship, kindly be pleased to allow me to withdraw this petition as per instruction of my petitioner.
You want to withdraw?
Yes.
Why?
Yes, my lord.
You are coming in 93 matter, master roll workers, you are coming now again
Petitioners
and
have
again.
instructed me. Petitioner, as per the instruction of my petitioners.
No, but there are suppression of facts
There
here,
may be some technical difficulties.
technical difficulties. All right, we'll keep an eye. Your name, please?
PK, Probationary.
Mrs. P.K. Devi, Learned Counsel for the petitioner, seeks leave of this court to withdraw this writ petition with liberty to file a post after rectifying the defect. Mr. B. Bora, Learned Government Advocate, Assam is present and does not have any objection if the prayer is allowed.
Okay.
The writ petition is accordingly disposed of on withdrawal with liberty of speech. Alleging violation of the right to be considered for promotion to the rank of constable arm branch, constable bracket AD. The instant writ petition has been filed. Heard Mr. F. Z. Mazumdar, Learned Counsel, appearing for a petitioner. Mr. R. Dhar, Learned Government Additional Senior Government Advocate, Assam. appearing for the respondents, prays for some time to obtain instruction.
1, 2, and 3, madam.
Appearing for the respondents, 1, 2, and 3, prays for some time to obtain instruction in the law. NOM 6. Since Mr. Dhar has accepted notice for respondent numbers 1, 2, and 3, no formal notice is required to be sent to the said respondents. To the respondents, said no, respondent, extra copies of the petition be furnished to the landed government advocate so as to enable him to obtain instruction file application. Yes.
Item 13.
Name, please, your lordship.
Yes.
Lordship, petitioner is agreed with the disagreement note issued by the commandant CSF unit IOC Bongaigaon. Your lordship will find at least 62 micro. Lordship, disciplinary proceeding was initiated against the petitioner under Rule 36 of CISF rule, my lord. The finding of the inquiry report is that at page 63, relevant portion, your lordship will find.
So what is your grievance here? The
Lordship,
disciplinary authority has disagreed with the finding.
disagreed and more so, my lord, at para 6, my lord, of the disagreement report 64, my lord.
So what is wrong with it?
So charges proved. Yes,
can-
declared charges proved without
That is-
any further inquiry, anything.
No, that's permissible. That's the law.
Without any inquiry. madam.
No inquiry is required. That inquiry report itself is the basis. What is the material comes out in the inquiry report. Inference, whether the charge is proved or not, may differ. The disciplinary authority may disagree.
Yes.
Were you given a notice before that? You are asked to show cause?
That is in the disciplinary
No,
proceeding. my
no.
lord.
Before disagreement was any notice issued?
No, nothing.
Then it's
That
going.
was not issued.
Then it will go.
That was not issued, my
My
lord.
lord, one.
Let us dispose of the writ petition on Friday.
Yes, my
You
lord.
tell your
Well-
clients that is the law.
My lord.
They
but-
cannot disagree. He cannot disagree without giving him an opportunity to.
My lord,
That's the
kindly-
law. You can't say anything against that. What
No,
do you
my
want to
lord,
say?
kindly, WBC 486, 2021, that is pending regarding the same disciplinary proceeding, that may become along with this petition, my lord.
No, but what is that about?
That was that memorandum of charge was silenced, my lord. The
Hmm.
notice was issued.
That has
to the
become
respondents.
infractions now
That has become infraction.
on Friday.
Friday,
Mr.
no,
D.
Friday,
Bora-
I am not available, my lord.
Friday.
Then tomorrow,
Tomorrow,
tomorrow.
yes, ma'am.
Mr. D. Bora, Learned Counsel for the petitioner also heard Ms. Again, Learned CDC, appearing for the respondents,
Kindly.
prays for posting this matter again tomorrow so as to enable her to obtain written instruction as to whether the disciplinary authority had issued any notice upon the petitioner before issuing the order disagreeing with the findings of
Yes.
the inquiry officer. Stop. On the request of Ms. Gayan, this matter will be listed along with WPC number
486, 2021.
486 of 2021. Yes. If no notice has been issued, we'll set it aside.
Yes, ma'am.
They should gracefully withdraw it. If they withdraw it, then they can issue notice and go ahead with it. Otherwise, we'll set it aside and the matter will be over. Please tell them.
Yes.
We will go by the law. They want to go or not, their choice. Yes,
Lordship, tomorrow.
tomorrow.
Master, yes.
Item 14.
May I please, your lordship?
Yes.
The matter related delay in disposing of my pension matter, my lord. My lord, earlier, my husband died, my lord, as a master worker in 2000, 2000. Then I approached the Honorable High Court, page 29 by writ petition. Where Honorable High Court give a direction.
So notice has to go here.
Yes,
Yes. But we'll have a short notice,
Kindly, my lord.
pension matter.
2 weeks.
2 weeks time. 3 weeks. All right.
Three
Heard
weeks.
Mr. S.C. Biswal and counsel appearing with petitioner. The petitioner is aggrieved by non-payment of family pension. Full stop. Mr. N. Upadhyay,
1, 3, and 4, lord.
Learned Standing Council, Irrigation Department, has prays for 3 weeks time to obtain instruction in the matter. NOM 29th of March 2023.
Extra copies I have to give them.
Since Mr. Upadhyay has appeared and accepted notice on behalf of respondent numbers
1, 3, and 4, lord.
1, 3, and 4. Mr. P. Nayak, Learned SC Finance for respondent number 2. Mr.
CS Azarika for
CS Azarika for respondent number 5. And Mr. A. Hassan for respondent number 6. Service of notice is deemed to be complete in this case. Extra copies, requisitive numbers,
Hello, ma'am.
furnished-
pendency of the.
furnished to the Learned Departmental Council within 3 days so as to enable them to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing. It is also made clear that tendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law. We say advice, list this matter again on 29th.
All right.
The DLC recommended my case, my lord, but the SLC rejected on a technical ground. The consideration of the DLC is at page number 18, my lord. Page number 18, my lord, serial number 2, my lord.
So notice has to go here also. Heard Mr. A.K. Barua, learned counsel for the petitioner. The petitioner is aggrieved by rejection of his case by the SLC for appointment on compassionate ground. Mr. C.S. Hazarika, learned government advocate Assam prays for and is granted 4 weeks time to obtain instruction in the matter. NOM 4 weeks since Mr. Hazarika has appeared in accepted notice on behalf of respondent numbers 1, 2,
And 3.
and Miss N. Bora, learned SC Panchayat and Rural Development Department, Assam, for respondent numbers 4 and 5, service of notice, Bagini Didi. Service completion, extra copies.
Yeah, at least. In spite of the order of this court, my lord, the state level committee has not considered my case, my lord, regarding compassionate appointment, my lord. Page number 40, my lord, page.
It is alleged in this writ petition that notwithstanding the direction issued by this court, the state level committee has not considered the petitioner's case for appointment on compassionate ground. Full stop. I have perused the amendments made in the writ petition. Full stop. Mr. D. Bora, learned government advocate Assam, prays for some time to obtain instruction. Before they were heard, Mr. F.L. Ashwin, learned counsel for the petitioner. NOM 6 weeks since Mr. Bora has appeared in accepted notice on behalf of respondent numbers.
Not one, your lordship. Two, only two.
Respondent number 2 and Miss
P. Naidoo appearing for Mr. Aranda.
P. Zaidin.
Appearing for Mr. Arandas.
Why didn't you come near the microphone?
P. Naidoo appearing for Mr. Arandas.
P.
Naidoo.
Naidi.
Respondent 1, 3 and 4.
For respondent numbers 1, 3 and 4, service of notice complete.
My lord, pendency of the writ, my lord.
Extra copies may be furnished.
Yes.
They have not furnished any copy to us.
Pendency knowledge. Extra copies are facilitating disposal.
Item 17.
Wait, please. Item 17 is connected with item number 53 and 54.
These are those same.
Only one thing, my lord. There's an order of this court where the challenge during the pendency of the case, the matter came up for vacation and the court gave us liberty that you challenge the 18th. So we got a liberty and these matters are coming up tomorrow. And in fact, these matters may be tagged up, notice may be issued with that order.
These matters are listed.
Yes,
Before
the
which
first
court?
batch is already Justice D. Borua's court tomorrow. It's the first batch. From the PWD, the hearing has commenced. So we were given a liberty that you challenge the 80 because I have two grounds, the 18 OM and the rules. I have two grounds of challenge. So the Learned Singh just said that liberty is given to you because during the pendency, this OM came. This was pending from 22. So your lordship, a notice and maybe tagged up tomorrow.
Tomorrow taking up will not be possible. Then you make a mention.
Yes, I'll make a mention there, at least notice and subject to all in the higher cadre subject to the result. That order your lordship has already given in the Langhasas case.
Any promotion will be subject to.
Yes, that order is already, we have
Mr.
annexed.
D.
We have annexed.
Mr. D.K. Das, counsel appearing for the writ petitioner. The basic challenge in this writ petition is pertaining to the legality and validity of the OM dated 18/1/2023. It is submitted at the bar that similar writ petitions raising the same question of law are pending before this court. Full stop. In view of the above, issue notice of motion returnable in 4 weeks. Who is appearing for whom? Since Mr. D. Nath, Lanet, senior government advocate Assam has appeared and accepted.
1, 2 and 4.
1,
2 and 4.
1, 2 and 4.
And rest, my lord, I will appear. 3, 5, 6, 7.
And Mr. R. Dhar, understanding council, WPT and BC, as well as PWD Assam has appeared for respondent numbers 3, 5, 6 and 7. Service of notice in this case is deemed to be complete. Extra copies of the writ petition will be furnished to the learned departmental council. Heard on the prayer of interim relief. Considering the facts and circumstances of the case, it is hereby provided that any promotion
To the high.
given, any promotion to the higher rank given during the pendency of this writ petition on the strength of the OM dated 18/1/2023 shall be subject to further orders that will be passed in this case. The same order in which are the
Yes,
other
53 and 54 same.
53 and 54 parties hearing also same
Yes, and
list along with,
we can make a mention.
you make a mention, yes. 53 and 54, same order. Check with the. All right.
Obliged. Maybe. Disciplinary again, appointment Gaon Pradhan Miller. I will explain the provision of the Assam Land Tribunal. I have filed an appeal before the Western Regularization Commission. But on there was filed on 9th of January. But till date, nothing has been done, 7 except putting the number. So my prayer, Your Worship, is very simple like that the appeal may be disposed of by the authority.
Heard Mr.
And
Rashid,
our
learned
post
counsel
may
for
not
the
be
petitioner,
filled up.
also heard Mr. C.S. Agrawal, learned government advocate Assam, as well as Mr. S. Datta, standing counsel PNRD. Revenue Department Assam, appearing for the official respondents full stop. The writ petitioner hearing had applied for the post of Gaon Pradhan for charge number 15, circle dash Bagbor of village AG, capital A, small g, Mandia, in the district of Barpeta, in response to the advertisement notice dated 3/9/2022. Full stop. On conclusion of the selection process, the respondent number 5 was selected for appointment as Gaon Pradhan. Full stop. According to the writ petitioner, the respondent number 5 has 3 children and therefore did not qualify under the advertisement notice dated 3/9/2022. Notwithstanding the same, his name has been recommended for appointment as Gaon Pradhan. First step. Mr. Rashid submits that his client has filed an appeal which was registered as
Page 35 million.
RR 4/2023 before the Lower Assam Commissioner. When did you file it?
It was filed on 9th of January million.
On the 9th of January 2023. But till today, no steps have been taken for disposal of the appeal. First of all, aggrieved thereby, this writ petition has been filed. There is no doubt or dispute about the fact that the appellate remedy is available to the petitioner under the, which is that
162 C of the executive instruction.
Inspection.
under
Under Assam Land Regulation.
under section 163.
162C
C.
of the executive instructions under the Assam Land Revenue Regulations.
Of the executive instruction issued under the Assam Land and Revenue Regulation.
1886.
If that be so, the respondents would be obliged to dispose of the appeal by the petitioner in accordance with law. First of, in view of the above, and as agreed to by learned counsel for both the sides, this writ petition is being disposed of by directing the respondent number 3. Is it respondent number 3?
Minor.
3 or 2?
Two.
Respondent number 2 to consider the appeal preferred by the petitioner and dispose of the same by a reasoned order as expeditiously as possible, preferably within 8 weeks from the date of receipt of a certified copy of this order. With petition stands closed. Yes.
May I pray one thing, one post may not be filled, that post may not be filled up.
Wait, please, lawsuit. Same matter, my lord, as item 18. But my lord, I am relying on 2 different orders passed by the Supreme Court, my lord. Original in one order, my lord, status quo was directed to be maintained. In
This is
another-
charge number 17.
Yes,
And
my
his
lord.
was 15.
Yes, my lord. My lord, and in another case, my lord, this honorable court, my lord, directed the respondents, my lord, not to give effect to the release order, my lord.
You prefer an appeal?
Yes, I have preferred, my lord. I have preferred the appeal, my lord, that has not been disposed of till today, my lord. That is why, my lord, my prayer is that, my lord, let the commissioner dispose of my appeal, and till then, my lord, the status quo as on today may be maintained, my lord. As the order has been passed by the another coordinated basis of the Honorable Court, my lord, in annexure 9, my lord, page 38 onwards.
No order of appointment has been issued.
No other appointment has been issued, my lord, till today, my lord.
All right, take down heard Mr. Ayed Sekal and his counsel appearing for the. That line we will add in the other matter also.
Yes.
That before any order of appointment is issued, that line will be added. You should dispose of the appeal with a reasonable. Yes. Heard Mr. Ayed Sekal and the counsel for the petitioner. The petitioner had submitted application in response to the advertisement notice dated 3/9/2022. The writ petitioner hearing had submitted his application for appointment with Bhav Pradhan in respect of charge number 17, Bagbor Moja under the Bagbor Revenue Circle in the district of Barpeta. However, on conclusion of the selection process, the respondent number 6 was selected for appointment of Bhav Pradhan. According to the petitioner, the respondent number 6 does not fulfill the eligibility norms under the advertisement notice dated 3/9/2022. Notwithstanding the same, he has been selected for appointment in Bhav Pradhan. Mr. Sekar submit that on when did you file the appeal?
On 22/2/2023, my lord.
On 22/2.
My
2023, the petitioner had submitted an appeal before the respondent number 2, assailing the respondent number 3, assailing the selection of the respondent number 6 for appointment as Bhav Pradhan. However, till date, submits Mr. Sekar, no action has been taken to dispose of the said appeal. Ms. A. Talukdar, Learned Government Advocate Assam, and Mr. S. Bhatta, Learned Standing Counsel, Revenue Department, appearing on behalf of the official respondents, have submitted that an appeal would lie under section 162 bracket C bracket close of the executive instruction issued under the Assam Land and Revenue Regulation, and therefore the respondent number 3 would be required to dispose of the said appeal by a reasoned order. In view of the above and considering the facts and circumstances of the case, this writ petition is being disposed of by providing that the respondent number 3 shall consider the appeal filed by the petitioner, numbered and registered as.
My lord, it has not been registered till today.
By the petitioner within a period of 8 weeks, as expeditiously as possible, but not later than a period of 8 weeks by a reasoned order. Until such time, the appeal is disposed of. No order of appointment would be issued in favor of the selected candidate.
Last order, Lordship, court has directed the petitioner to file a stay application.
No, in this case, interim order prayer is there, my lord, in my appeal. So we
Page
find the
44.
Writ petition
appeal, my
starts
lord.
disposed of. Yes, that's right. But just add that until such time, no order of appointment would be issued in favor of the selected candidate. Just that line should be included in the last item 18. Govinda should not take.
My lord, it seems they have filed and reply, my lord. So, my lord, let the matter come up on next week, my lord. They are filing a reply to.
Final vacation petition application.
We have filed a vacation.
And I have
petition, my
submitted my
lord.
reply, my lord, with certain important facts, my lord. So they need to submit there probably.
When
My lord, can it take a 14th stock and dispose of along with the IA, my lord, the main case, small issue only. 14th of March, my lord.
when did you file the reply?
I did not yesterday. It came to your lordship. I give them copy also of that. They sub the copy, maybe in the office.
Mr. Ardhar, Learned Counsel for the applicant submits that copy of the reply filed by the writ petitioner stroke opposite party has been received by him only day before yesterday. And therefore, this matter will be posted again on 14th of March 2023. So as to enable him to obtain instruction. Mr. M. Nath, Learned Senior Counsel, assisted by Mr. Bhattacharya is present on behalf of the lead petitioner stroke OP. Mr. P. Nayak appears for the
1, 2, and 4 law, finance.
for the finance department. On the request of learned counsel for the applicant, let this matter be listed again on 14.3.
Of this point.
May it please your lordship, my lord, to file I for implement of the opposite party as respondent number 7. My lord,
Why you want to implement?
my lord, in fact, my lord, the petitioner submitted a leave application before that person, my lord, and that leave application was not taken into consideration. Ultimately, in her post, some other person has been selected and appointed, my lord. That is the grievance. my lord.
Who is the respondent number 7?
Respondent number 7 is the my lord, supervisor of the Shalmara Sub Health Center.
No, but you want to.
Under her, the petitioner was working as an ASHA worker.
Who is appearing for the other side?
Thank you. My lord, in the petition, we have not made him party.
Why you want to implement the person by name?
Because we submitted our medical leave application before that opposite party, and my application for medical leave was not taken into consideration.
Is that statement made in the writ
Yes,
petition?
my lord, yes, my lord,
Where, in which, let's see the writ petition, which paragraph of writ petition?
my lord. My lord, yes, my lord. Para 3, my lord. My lord, we have not made any statement, but we have filed an additional.
Then I will not allow it.
We have filed an additional affidavit, my lord, to that extent. my lord. We have made a additional affidavit.
That can't be done. Mr. Sigdar, it cannot be done. Either you will have to amend your writ petition or you have to withdraw it and file afresh.
My
What is the
lord,
point in implementing someone by name if there is no allegation? Additional affidavit is something else. Additional affidavit is clarificatory in nature. You can't build up a new case by additional affidavit.
my lord, there is an order for filing an additional affidavit. That's why.
I'm so sorry. Let it go back to another court then. I cannot pass orders which are not in accordance with law.
Yes, my lord, we'll file an addition, fresh application with the liberty to.
You want to withdraw and file.
Yes, my lord.
Have you understood the point?
My lord, earlier court has, this honorable court has allowed us to file an additional affidavit to bring that fact, my lord.
No, then you argue and satisfy me. You want to implicate someone
My lord.
as a party to the writ petition by on the ground that that person has some role to play. But there is no mention of anything in the writ petition. How can you implicate another person and then not have any statement in the amendment in the writ petition? What is this happening?
My
We
lord,
go by law, Mr.
My
Sigdar.
lord, we will file and fresh, my lord, it may be allowed to withdraw, liberty to file a fresh one. my lord.
That you can do. Either you tell me that it is permissible or you withdraw. What has been passed by which I can't say anything on that. What purpose will be served by impleading someone when there is no pleading against the person in the writ petition? And you want to implead an official in by name, personal capacity? You want to withdraw or?
Yes, my lord, we will be allowed to withdraw the liberty to file.
All right, Mr. In the writ petition, you write, Mr. A.R. Sigdar, learned counsel for the writ petition submits that some vital facts could not be incorporated in the writ petition at the time of filing the same, and hence he be granted leave to withdraw this writ petition with liberty to file afresh. Prayer allowed. Mr. D. Upamanu, learned standing counsel, Health Department, Assam, as well as C. Hazarikal and Government Advocate, Assam, are present and do not have any objection if the prayer is allowed. Stop. As such, now prayer allowed. Prayer allowed. Writ petition stands disposed of on withdrawal with liberty as prayed for. And then you write, in view of the order passed in today in WPC number 8122 of 2022, this IS stands infractured and is accordingly closed.
Leave the-
Item 21 for admission.
My lord, in the last occasion, lordship had directed or asked us to go for a compromise and out of court settlement. Yesterday, they have forwarded their offer, but going by that offer, they have declined to pay any wages for the period he was from the date of dismissal to the date of reinstatement as per the award, and my lord, up to his date of retirement. Even my lord, the PF contribution, employers contribution for that period are there, they are not offering. So my lord, I talked
The
to
matter
my,
will have to get heard.
yes, my lord, I talked to my client, he said that he is willing to give up some portion of his back wages, but he cannot agree to total denial. And another aspect, my lord, during his service period, he had taken loan from the bank under different heads. So on the day on which he was removed from service, he could not pay the loan amount. As a result, my lord, they have continued charging interest. So if the back wages are not given, and then whatever gratuity and leave encashment he will get, it will be adjusted with his entire dues. So my lord, perhaps it is not going to work, my lord.
Well, then we fix it for.
My lord may take up this matter tomorrow. It is.
Tomorrow I have-
Cannot be taken up before 21st March. Choose a date after 21st March.
Must.
Every matter can't be taken up tomorrow. Everybody wants tomorrow, but they can't do it.
Since a lordship had heard it.
No, that's right, but it can't be done. We'll have it on
16th
21st March.
16th, if it is otherwise
Not
not on
possible.
subject.
You'll get it, but it could be item 60 or 65, something like that. You want it.
21st month.
Yes, our
the
Mr. B. Kaushik, learned counsel for the petitioner, as well as Mr.
23rd.
S. Chakraborty, learned counsel appearing to the respondent, have both submitted that pursuant to the order dated 7/2/2023 passed by this court, some attempts were made so as to work out a negotiated settlement by and between the parties, but the attempt has ended in failure. As such, the writ petition be heard and decided on merit. First of Mr. C.S. Hazarika, learned government advocate Assam, is present on behalf of the state. On the request of learned counsel for both the sides, let this writ petition be listed again on 21/3/2023.
My lord, 23rd, my lord, 21.
23rd of March 2023 as a fixed item. The matter will be taken up for final disposal, parties to come prepared.
Interim may be continued.
Huh?
Interim order may be done.
Interim order passed earlier to continue till then.
Highly obliged.
Well, the matter relates to voluntary retirement. It's on a very narrow compass. On last occasion, my lord, the respondents were directed to produce the records. Well, our simple case is FR 56C, my lord. If I have fulfilled the condition precedent, my lord, then it is automatic. There is no question of any government accepting or it. In fact, my lord, by 3 letters at page 29, 30, and 31, my lord, the prayer for voluntary retirement was made, my lord.
So what are the facts? We have to go to
Yes.
the facts again.
If you lordship to kindly come to page 29. This was the first communication. It was on, my lord, 29/12/17. That, sir, I was transferred from Silchar Medical College to Guwahati Medical College by order dated 8th of December 2016, and I joined GMC on 23rd of December. As per the order, I had to strengthen cardiology at Fakhruddin Ali Ahmed Medical College, Borpeta. Accordingly, I had submitted detailed plan for the same. As my daughter was appearing in HSLC exam in March 2017, it was not possible for me to go to work at Borpeta. Subsequently, due to my family problems and my physical illness, I took earned leave and medical leave. Sir, as my children are studying at Silchar, I am having lots of medical problems. Partial lung resection, cervicolumbar spondylitis, hepatitis B, coronary angioplasty. It is physically not possible on my part to work at FMC, where there is no cardiology department and no subordinate staff. Considering these facts, I request you to kindly revise the order and place me either at SMC or GMC. in the interest of public service. If that is not possible, please allow me to go on voluntary return. Actually, I was transferred from Silchar to Guwahati, but instead of Guwahati, my lord, I was supposed to work at Borpeta. There is no facility, there is no cardiology department. I'm a patient with angioplasty and amongst others. So, my lord, I said either you keep me at Guwahati or send me back to Silchar, or if it is not possible, then please consider my prayer for voluntary return. Now, this was followed by subsequent letters, my lord. Now, if we take this date, my lord, 29/12/17, then my lord, 3 months period expired on 29/3/18.
Why 3 months? That is the requirement.
That is the requirement. My lord, will kindly have a look at it's quoted. Para 15, we have quoted the provision, my lord. Page 14, para 15. Any government servant may, by giving notice of not less than 3 months in writing to the appropriate authority, retire from service after he has attained the age of 50 years or has completed 25 years of service, whichever is earlier. The condition precedent is, my lord, I must give a 3 months notice, and I should have completed the age of 50 years or I should have completed 25 years of service. And my lord, Supreme Court interpreting FR 56 has said it is a condition of service. As you have power to compulsory retire somebody as a punishment, we also have a right. Now, there is no question of, my lord, accepting my resignation. It's not a normal resignation where there is a requirement of, my lord, acceptance is there. I have placed the 2 judgments the other day, my lord. Your lordship will kindly permit me to place them
Yes.
once again.
Yes.
That Dinesh Chandra Sangma, 1977, 4 SCC 441. My lord, may kindly come to para 15. It is the cardinal rule of construction that no word should be considered redundant or superfluous in interpreting the provisions of a statute or a rule. Explanation 2 does not say an express or implied term of employment, but refers to an express or implied term of his contract of employment. If the language of explanation 2 were different, namely an express or implied term of employment instead of contract of employment, the position would have been different. Explanation 2 in Rule 1119, albeit a panel rule, takes care of use of the word contract of employment and necessarily exclude the 2 categories of employment, namely one under the central government and other under the state government. Explanation 2 only takes in its sweep the 3rd category employment, where relationship between employer and the employee is one governed by contract of employment. Since FR 56 is a statutory condition of service which operates in law without reference to a contract of employment, there is nothing inconsistent between Rule 119 and FR 56. But these are the observations in the facts of this case. Now please come to para 16. The appellant has voluntarily retired by 3 months' notice, not in accordance with an express or implied term of his contract of employment, but in pursuance of a statutory rule. Explanation 2 to Rule 119 makes no mention of retirement under a statutory rule, and hence this same is clearly out of the way. The submission that Rule 119 is superimposed on FR 56 has no force in this case. The High Court committed an error of law, holding that consent of the government was necessary to give legal effect to the voluntary retirement of the appellant under FR 56C. Since condition of FR 56C are fulfilled in the instant case, the appellant must be held to have lawfully retired as notified by him with effect from August 2, 1976. So, my lord, it's a statutory rule. It speaks of fulfilling only 2 conditions, that there has to be a 3 months notice and the incumbent government servant must be of 50 years of age or should have completed 25 years of service. Then, my lord, it is automatic. The other decision which I placed was, my lord, 1995 supplementary 1 SCC 76. I think it is there, my lord. Kindly come to para 5 of that later judgment.
So his 3 months would have expired on 29th of March 2018.
Yes. 28 in fact,
Sorry,
28.
28. Mr. Bora, while we hear the argument this side, tell us from 28th of March, that is for the month of April 2018,
Yes.
was he paid his salary, etc.?
My lord,
Check it up and give the answer when we hear you.
Yes.
regarding salary, my lord, it is not there, but thereafter he has joined his duty, my lord. Thereafter he has joined, and after that he has applied for leave also, my lord. So that his payout for here is gone, my lord, because after that he has joined and he has paid for leave, my lord. Record is there, my lord.
Anyway, my lord, I'll deal with that, my lord. My lord, may kindly come to the second judgment. 1995 supplementary 1 SCC, page 76, para 5. The second aspect of the matter is that it has been held by 3-judge bench of this court in Dinesh Chandra Sangma versus State of Assam, which deal with a perimetry of provision finding place in Rule FR 56C of the fundamental rule, that where the government servant seeks premature retirement, same does not require any acceptance and comes into effect on the completion of the notice period. This decision was followed by another bench or 3 judges bench in so-and-so versus so-and-so. Now, my lord, the legal position is absolutely clear that there is no question of acceptance. If the government is under the impression that since you have not accepted the offer of voluntary retirement, therefore it has not taken effect, is not correct. But subsequently what had happened, it cannot have any bearing on, my lord, the legal fiction which is created by the judgment. But the moment the 3 months period ends, my lord, they are bound to accept it. Now, thereafter, my lord, they have also initiated a disciplinary proceeding against me, and for allegedly, my lord, overstay of leave and all, they have also dismissed me from service. It doesn't make any, my lord, sense. Once when, my lord, the relationship of master and servant has ceased on 28/3/93, thereafter what I did, what they did is immaterial. There was no relationship of master-servant after 28/3, my lord, 2019. It is their wrong understanding that because they have not accepted the offer, therefore, my lord, they felt they still have power to proceed against me, allow me to work, etc., 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 so on and so forth. That is not going to come to their aid, neither to my rescue. My humble submission is, my lord, the moment 3 months ends, it's end of the matter. And Supreme Court has said, my lord, it is a condition of service. As you have power to compulsory retire somebody, the employer has also been, the right of the employer has also been recognized by the statute. So had it been the intention of the rule-making authority to impose further condition of that, no, the government will take note of whether it will be in public interest, whether government there should be acceptance. When the rule-making authority has not emphasized those, I don't think they can, my lord, ponder over it any further. So that being the position, my lord, the relationship snapped, and therefore master-servant relationship is no longer there. So once it is not there, there is no other question, my lord. By operation of law, the master-servant relationship ceased on 28th of March 2019. That is my humble submission.
And what do you have to say? He says your client is joined back after that.
My lord, even if I have joined, my lord, even if they have permitted me, what difference would it make, my lord? Will it not be, and my lord, unauthorized action either on my part or their part? My lord, at times what happens, my lord, we as a government servant, we do not have any choice at times. My lord, the lordship will kindly appreciate the predicament of the employees also.
Now, you are assailing the order of dismissal.
Of course, my lord.
Where is that order? Where is
Yes.
that order?
Page 51. In fact, my lord, even the order also takes note of my request for voluntary retirement. Whereas disciplinary proceedings were conducted against Prabhas Chandra Sharma, Professor, Department of Cardiology, while later dated so and so, and he was discharged. He was charged with negligence of duty, insubordination, violation of Rule 3C of the Assam Civil Services Conduct Rule 1965, and gross misconduct. Whereas the inquiry officer submitted the inquiry report and while later dated, were in charge of negligence of duty, insubordination, in violation of Rule 3.1 of the Civil Service, and gross misconduct against Prabhas Chandra Sharma has been established. Whereas the report of the inquiry was communicated to Dr. Sharma by later dated so and so, thereby giving him opportunity of submission of representation, if any. Whereas Dr. Sharma, by his representation dated 17/5/21, requested the government kindly to grant him earned leave, medical leave, and voluntary retirement from service. Whereas on examination, it was found that representation of Prabhas Sharma did not contain any new facts which warranted review of the penalty decided to be imposed upon Sri Prabhas Chandra Sharma. Whereas Assam Public Service Commission communicated by later dated that it agrees to the government decision of imposing a major penalty of dismissal from service, which shall ordinarily be a disqualification for future employment. Now, therefore, government is pleased to accept the report submitted by inquiry officer, not to impose the penalty of dismissal from service, which shall ordinarily be a disqualification for future employment under rules so and so. Now, my lord, let us test this also. Now, if after overstay of leave, why you allowed me to join? If you have allowed me to join, why have you initiated this proceeding? Either way, my lord.
Where is the charge memo?
Page 32. Basically absence. Whereas in pursuance of the government notification, you were transferred and posted at Guwahati Medical College against the vacant post of Professor of Cardiology Department and attached in the same capacity at Fakhruddin Ali Ahmed Hospital, Borpeta. Whereas you joined at the Guwahati Medical College on 23/12/2016, but remain absent from duties at Fakhruddin Ali Ahmed Borpeta without any permission or grant of leave. Whereas you have remained unauthorizedly absent for a long period from your duties and submitted applications for leave, which have not been recommended by Principal cum Superintendent of the GMC and Borpeta College and Director of Medical Education, as a result of which the patient care and academics have suffered badly. Whereas as per the rules, leave cannot be claimed as a matter of right. Therefore, you are directed to submit explanation within 7 days from the date of issue of this letter as to why disciplinary proceedings should not be drawn against you for your misconduct, negligence of duty, insubordination.
This is the show cause.
Yes.
36, 37.
And my lord, charge sheet is on page 36. That is the basic, my lord, grievance. That is formal is at page 36. Same charge. Now kindly look at my reply, my lord, at page 38. That sir, I joined GMCS on 23/12/16 and attended FA Borpeta College. I availed winter vacation in January 2017, received salary for that month. Thereafter, I applied for earned leave and medical leave on different dates, but none of them are granted even after my repeated request letters. The reason why my applications were only forwarded but not recommended is unknown to me. As I am suffering from various chronic and disabling disease, for which I need family support, I request for my transfer to SMC or Guwahati or grant voluntary retirement by my later dated so and so, so and so. For your information, sir, I joined APSC confirmed regular service in 1990. I was not aware till recently that I was transferred to Jorhat on 31/12/19. Sir, I was called for hearing on 1st of October in the office of Krishna Gohai, Special Secretary, where I inspected my application in the file and narrated the same thing. Regarding the statement of allegation, after availing winter vacation in January 2018, I joined FMC on 1/2/18 On 1/2/18, I applied for casual leave for 7 days with effect from 2/2/18 at FMC and came back to Guwahati. On 7/2/18, sent another CL application for 7 days with effect from 8/2/18 to my FMC, that is Medical College Borbetta by hand. On 8/2/18, I applied for 5 days CL with effect from 9/2/18 in GMC office. On February 2016, 2018, I joined back at GMC office. February 4 to 11 was Sunday and 10 was the second Saturday holidays. The list of documents are letters from principal, GMC and FMC mentioning my CL application, and document number 1 is forwarded letter from DMB covering these letters from principal. These are self-explanatory and should not raise any confusion or controversy. Sir, I totally disagree with the allegation brought against me like negligent misconduct and insubordination. As such, I am suffering a lot financially, and this sort of allegations are harassing me mentally, which are detrimental to my health. I request you kindly to grant my unleave medical leave, extraordinary leave, or grant me voluntary retirement as applied. Any unintentional foul mistake may kindly be forgiven, for which I shall remain ever grateful to you. So, my lord, this is the circumstance. It can't be, my lord, government is always right and employee is always wrong. Now, this is the attitude now, my lord. As if, my lord, they can do no wrong. The issue is, my lord, you have transferred me to Guwahati, but you have attached me to Borbetta. In other words, you have transferred me to Borbetta. Why you did not write that order? And I am a cardiology patient. There is no cardiology ward. I have been given the responsibility of setting up that department. My daughter was appearing in, my lord, HSLC examination. Where do I go, my lord?
Yes.
Assuming, my lord, I am supposing, my lord, there was no voluntary, application for voluntary retirement. Is the punishment not shockingly disproportionate?
That's
my
what I
lord?
was asking you. Is that one of your ground?
No, yes, of course, my lord, no. But I was thinking of, my lord, going at the threshold. It is shockingly disproportionate. And kindly see the circumstance. Is there any way government could have
So,
meeting?
Mr. Chaudhary, supposing the court agrees with your first limb that it was axiomatic within 3 months, exercise of 3 months, everything was over. There, of course, it appears that even the petitioner knew that voluntary retirement was not affected, because he also wrote in 2020 that allow me to go on voluntary retirement.
No, I
So-
thought, no, my lord, my
That's all right.
understanding-
That's all right. Then in that case, supposing the court finds that this penalty, order of penalty is shockingly disproportionate, what is the relief that can be granted now? He is already retired. The question
I have retired, but my lord, they can always,
Not
reduction-
retired.
Huh?
Not retired, my
My
lord.
God.
In 2022, he is 60 years. So retirement age is 65
Oh,
years.
65 now. No, lordship can always say that interfere with the punishment and let them consider, let them pass an order on my voluntary retirement. Assuming, going by their understanding of the law, my lord.
Why are you harassing this man?
No,
He
my
wants
lord.
to go, let him go. What is the big deal about it?
But my lord, the VRS application, my lord, that was filed in 2017, my lord. Now, my lord, that is time barred because after that he has joined, because petitioner has joined, he has applied for EL, and subsequently in the year 2019, my lord, he has been transferred to Jorhat Medical College. So within a period of less than 1 week, my lord, he was informed. Subsequently, he has filed an application saying that he was not aware of the transfer order to Jorhat. But then also he had sufficient time to join there, my lord. So thereafter also he remained absent, my lord.
But that's all right. But Mr. Bora, assuming that he had some issues.
Yes, my lord. If you, and
So how can you dismiss someone from service?
yes, my lord, regarding the
That order
that
we cannot
punish-
sustain.
yes, my lord, that your lordship may interfere, but regarding the VRS application, that was never processed and that was not filed in proper manner.
Because his own statement is there during the DP that he has not filed the VRS application in proper format, enclosing all the documents. Because if he is applying for VRS on medical ground, he has to submit all the supporting documents along with the application. So in his own statement, he has admitted it that I have not submitted the VRS application by filing enclosing required document. So the VRS issue gone, my lord. And there is a noting that in the year 2000.
But he can file a fresh application for.
Yes.
That can be done, my lord. After.
No, my lord,
if,
what
my lord,
prevented
if
the
your-
government from
if
saying that
if
this is
your
not in
lordship-
form, please file it in form.
If
You
you
don't
don't
respond to
interfere
it.
with the dismissal order, my lord, that remedy will be open for him, my lord, after that. But my lord, the VRS, because never, my lord, because it is his duty also, that if he has genuine problem, he has to file the leave application and other application in proper format. He has admitted before the DP that he has not.
That is all right, Mr. Bora, that
Yes,
is all
sir.
right, but after all, these are doctors.
Yes, my lord, that is
They
true,
are
my lord.
also serving the people in Singapore.
Even we want him, my lord, because he is a good cardiologist, my lord. That's why his service.
But
was-
if you want him, then is this the treatment you are giving
No,
him?
my lord, because
Huh?
after his long unauthorized absence, even thereafter, he was allowed to join in Jorhat Medical College, my lord, in the year 2019. Then also he did not join, my lord.
See, the point is, if you want someone,
Yes, my lord.
this is not the way you get them.
No, my lord.
They are
Since
professionals.
2016, my lord, he was unauthorizedly absent. Thereafter also in the year 2019, my lord, he was posted in Jorhat Medical College. That's why, my lord, because we want a doctor like him. That's why till 2019, in the year 2000, if your lordship kindly peruse the enquiry report for a moment. Enquiry report at page 40, my lord.
42.
That page,
The relevant portion at page 45, my lord. 45, the conclusion part, my lord.
this is the enquiry report.
Yes, my lord, the conclusion part, my lord.
Hmm.
On the charge of not obeying government order number so and so dated 31st December 2019 and not joining at JMCH, because by this order, my lord, even after his unauthorized absence, he was allowed to join in Jorhat Medical College. Dr. Prabhat Chandra Sharma stated that he was not aware of the order. In his statement on 1/10/2020, Dr. Sharma had stated that he came to know about the transfer order to Jorhat only from the SOCOS. The SOCOS was issued on 4/1/2020 and he submitted his reply to the SOCOS on 9/1/2020. Therefore, he was aware of the transfer order by 9/1/2020, the date on which he had submitted his reply to the SOCOS. Reply to the SOCOS is an annexure. Had he wanted to join at Jorhat or make any representation to government against the transfer order, there was still sufficient time. That then also the government could have considered, my lord. Thereafter also he did not join. That is senior government servant holding a post of professor and HOD, he willfully did not join or submit any representation after becoming aware of the transfer order.
No, that's all right, but Mr. Bora, you see, you can't treat someone like a bonded lever. You want him to join somewhere, you've transferred him, all right. He doesn't want to go, he has applied for leave, you don't want to give him, all right. He
has
wants
not
to quit.
applied in proper format, my
No,
lord.
that's okay. Have you intimated him that his application is not in proper format? Was there any intimation given?
But there was
And where
no-
is the order posting in that Borpeta? FAMC Borpeta, where is that order?
25 maybe.
Where is the order posting him at?
page 25, my lord.
Hmm. Page 25.
Yes, my lord.
Mhm.
My lord, prior to his transfer to Jorhat, my lord, all these were, my lord, because government, although he was unauthorizedly.
No,
absent-
just a minute, just a
Yes, my
minute.
lord.
This is an order of 8th December, is it?
Yes, my lord.
By this, he was transferred from Silchar to Guwahati.
Yes, my lord.
Then the posting is at Guwahati. How are you attaching someone in some other
My
place?
lord, for exigency of service, my lord, sometimes it can be done, my lord, and it is done in the department, my lord. My lord, assuming that that was harsh, my lord, then there That's why, my lord, he was again considered and Johar Medical College. All these was, my lord, not.
All right,
Before-
Mr. Bora, let's make it very simple.
Yes, my lord.
We can write a judgment. That's not a problem, and we'll do it if necessary. But writing a judgment will bring in many things.
Yes, my lord.
Are you willing to consider his application for voluntary retirement even at that stage, even at this stage?
My lord, that I cannot say, but
No,
if
no, I'm not asking you, your officials.
first, my
Then we
lord,
can write a short order.
my lord, first he has to join, my lord, because if his application for VRS has to be considered, my lord, first he has to come back to the service, my lord. So if he, otherwise, my lord, after, if suppose, if he is reinstated in service, then obviously his that right will accrue. But whether that will be considered or not, that I cannot say now. But as a matter of his right, he will get a right to be considered, my lord. But
And if supposing if he's reinstated, you'll have to issue an order posting him somewhere.
yes, my lord, that has to be done, my lord. And thereafter he can make an application, and which will be considered on merit, my lord.
That order cannot be treated as
No, my lord. No, my lord.
closure is difficult.
No,
Mr.
it is
Chaudhary,
like this, my lord.
on that application.
No, my lord, we cannot tinker with the legal position. Supreme Court has explained it. What is the purport of an application? If my language friend can show that there is a particular form, I'll be very obliged. I don't think there is any form. My lord, as long as the meaning is conveyed that I want to go in voluntary retirement, I think that's the end of the matter. My lord, this is not a tax return, my lord, that we are giving in a particular form. I'm conveying my intention. Either you give me leave or alter my transfer order or allow me to go on voluntary retirement. I think that's my right. The issue is whether that right has, while considering that right, my lord, of mine, whether they have extended a proper consideration, my lord. That's the issue. Anyway, let us be very practical about the whole thing, my lord. Now, my humble submission is, my lord, Lordship will interfere with this order of my lord dismissal. Lordship will direct them to reinstate me, and I'll, my lord, apply for voluntary retirement.
But they will also have to be given the right to consider a fresh
No, my
order.
lord, that in accordance with law, my lord. If the law envisages that they have a right of consideration, yes. If the law says there is no
But
right.
what we can clarify is first his application for voluntary retirement will be processed.
Yes,
And only thereafter.
yes.
No, but that will be the subsequent condition, my lord. He has to be reinstated, then he may make it his application. That may be considered.
No, my lord, the question is that law will take its own course, my lord, whether
Because the
there's a
thing is then, my lord, the petitioner is has got a lucrative practice at Silchar. So he doesn't want to go anywhere.
No,
my
that
lord.
is not my fault,
It is
my lord. If I have got a
down to
lucrative
LC,
practice, that means I'm a very good professional.
And at the exigency of service, my lord, his service is required in every medical college and hospital, my lord, as a senior cardiologist, my lord, because we are having.
You have any decision, can you hand
On-
over this shockingly disproportionate,
Yes, I'll give.
how, Mr. Kencho?
Tomorrow, 10:30, I'll give my lord, or Lordship one just now.
No,
Tomorrow at 10:30.
then we'll close it on Friday. On Friday, we'll close it.
Okay.
So and so for petitioner, so and so for the department. Let this matter be listed again on Friday, give Friday, they will fix part of the matter. Just
Why
on
are that? We'll get two judges.
but prima facie, I'm convinced that this order of dismissal was completely unjustified.
Yes.
On that, a little, spend another 5 minutes on that.
I'll do that.
You want to respond also, you respond. If you want to get any instruction.
No, my lord, we are ready to, if your lordship interferes with the dismissal part, then department will consider for imposing minor penalty or.
All right. At the same time, consider his application for voluntary.
Yes,
retirement. If submitted within 7 days in proper format,
yes.
that will be the order. I'll dictate it on Friday.
May I please, your lordship, item number 23, my lord. So the petitioner was appointed as a chairman of the Revenue Circle matters. He was appointed in the year 2013, my lord. Although he is working, my lord, but his salary was not, first salary was not released, my lord, due to want of the approval from the finance department, my lord. Accordingly, communication was communicated, my lord.
Yes, who's there in the finance department? Is the finance a party here?
Yes, my lord. Respondent number 2, my lord.
Respondent number?
2. The commissioner and the
Why
secretary.
his salary has not been given?
Lordship, my lord, that the prior approval, my lord, they have not taken approval from the, my lord, finance department.
Who has not taken?
By the authority, lordship, my lord, that who was the, my lord, that settlement officer.
Hmm.
My lord, that communication was made. It was, my lord, in my affidavit, I have stated in the paragraph, lordship. It was moved 2016 also, my lord, the finance department for record of approval.
But this appointment was pursuant to a proper selection process against.
No, lordship, not selection
No,
process.
He
Huh?
was appointed by the settlement officer, my lord,
Hmm.
against the vacant post, my lord. Two retired vacant posts was there, my lord.
Hmm.
And the petitioners were experienced persons, my lord. They were earlier also worked in the same office, my lord.
No, but how can that be? That cannot be done.
And the settlement officer accordingly appointed them, my lord, on application, my lord. Thereafter, my lord, he was
The
working
settlement
since
officer
2013, my lord.
Misunderstood his power. He did not have any such power. Who is settlement officer to appoint like this? What to do? This appointment is honest in the eye of law.
But since 2013, I am working without salary.
You
my
can't
lord.
get a mandamus. What is your stand, Mr. Gogoi? You can't do it. There are certain norms. Finance department has some responsibility. Suddenly you file a suit against the person who is appointed. Get his properties attached and recover the amount. What can the writ court do about it?
Without selection, my lord, already have stated. And my lord, as per the AFRBM Act, my lord, there will have to be prior approval from the finance department, including SIU and budget, my lord. And thereafter, it will have to be advertised, and only after selection, a person. can
Yes,
be-
your name, please.
A. Rashid, my lord. A. Rashid.
Either I'll dismiss or you withdraw and pursue whatever, but your client is not going to get anything from this court. It can't be helped. This
But,
type of appointments can't be made like this in government posts. So sorry. What do you want to do?
My lord, kindly adjourn the matter for them, my lord. I will.
You'll try somewhere else. Huh?
No, my lord. That is
Where you
not-
want to try? You tell me, I'll post it there. All right.
Next week, my lord.
Mr.
A. Rashid.
A. Rashid, learned counsel appearing for the petitioner. Sixth adjournment in these matters. Full stop. Both the writ petitioners,
Yes, ma'am.
where it appears that both the writ petitioners. No, you're right. Like it appears that the petitioners in both the writ petitions were appointed against vacant grade 4 post by the settlement officer of Dhubri and Kokrajhar district. Is it?
Yes.
Sometime in the year 2013. First of, however, since no salary has been paid to them till today, hence these writ petitions have been filed. First of, Mr. B. Gogoi, learned Standing Counsel Finance Department, Assam, has submitted that the petitioners were appointed not on the basis of any regular selection process, and no approval of the finance department, that is SIU, was ever obtained before filling up, before making any appointment against those posts. Full stop. Under the circumstances, no approval, no budgetary provision can be made available for payment of salary of the petitioners. Full stop. The aforesaid assertion of the learned departmental counsel could not be denied by the petitioners counsel. Full stop. If that be so, there is no merit in these writ petitions. However, since Mr. So-and-so is seeking adjournment with a request to post this case before another bench,
No, not another bench, my lord.
not another bench,
No,
how much time you want?
for 2 weeks, my lord.
For 2 weeks, hence this court is left with no option but to adjourn the matter. This order will be read by what to do. This will not work. You have to think of something bigger. No, but sympathies are there, but nothing can be done.
Yes, my lord.
You tell your clients to start working somewhere else.
Yes, my lord.
Nothing can be done. The Writ Court cannot issue directions for implementation of illegal orders. That is the law. 2 weeks has been given for the, so that you understand it. Otherwise, I would have dismissed it today itself. Yes.
VIP Lordship. Lordship, this is the promotion matter, my lord. And the promotion of knives of the rank has not been given to the petitioner, my lord. Due
Promotion to which post?
from warrant officer clerk to knives of the clerk, my lord. Due to his low medical category, my lord.
Yes.
Kindly see, my lord, page 30 and extra 11 of my writ petition.
Promotion not given or he was not considered for promotion.
He was not considered for the promotion, my lord, due to his low medical category. But that injury has been attributable to his government service, my lord. Court of inquiry is there, opinion is also there, my lord.
May I please, your lordship, lordship, my senior is out of station, so kindly adjourn the matter for me.
Then you will come.
Who is your senior?
SS Roy.
He is out of station. What to do?
Then next week, my lord, if possible, then dates may be given, my lord.
Next week is Holi.
Then after 2 weeks, my lord.
Promotion.
Promotion
not that
matter,
urgent.
my lord.
Nothing is so urgent. Your Mr.
V. Kumar, my lord.
Mr. V. Kumar, Learned Counsel is present on behalf of the petitioner on the request of Learned CGC. This matter stands adjourned for 3 weeks. List this case again as a fixed item after 3 weeks.
My lord.
Objection.
Replay, your lordship.
Item 26.
Item number 26, my lords, 2 weeks time may be granted to take some instruction from my client, my lords. Very compassionate.
On the request of Mr. V. Kumar, Learned Counsel for the petitioner, made with the consent of Mr. H. Chakravarti, Learned Government Advocate. This matter stands adjourned for 2 weeks so as to enable me to obtain updated instruction.
My lord. I give it.
Item 27.
My pleasure. Father, in this case, Father, the petitioner has been demoted from the post of superintendent of nursing to the post of assistant superintendent without issuing any notice, madam. And that was challenged before this honorable court. Now affidavit and all the pleadings have been.
Is there any interim order?
There is no interim order, madam.
There is no interim order. So she is in the demoted post now.
She is in the demoted post.
When was she demoted?
Madam, 28/9/2021, madam, page 36 of my petition.
And she is demoted from superintendent to?
Assistant superintendent. Earlier, she was promoted to the said post on 7/9/2021, that is at page 34. This is as per recommendation of the promotion committee, subject to reversion without notice and without assigning any change. CL number 3, Hamlata Khanikar, to Madam from the post of assistant nursing superintendent to the post of matron nursing superintendent. Okay.
Yes, then where is the order of demotion?
Lordship, page 36. Now, in this, so far as nursing service is concerned, the rule has come into force only in 1991. It doesn't prescribe the specific provisions for promotions. And the since prior to the coming into this operation of the 1991 rules, a practice was followed, for promotion, which was again continued even after the service rule came into force. Now the practice was, the entry level is the staff nurse, that is also as per the rules. Entry level is staff nurse, and for that the entries
So
from
this matter will have to be heard then.
yes, need to be heard.
We'll have it on a non-miscellaneous day. You're ready? If
Yeah.
pleadings are complete,
Yes, yes.
I put the records also.
21st. Mr. P.J. Sehgal and senior counsel appearing for the petitioner, as well as Mr. D. Gogoi, Learned Standing Counsel, Health Department, Assam, have submitted that this writ petition is ready as regards pleadings and can be taken up for disposal. Full stop. We'll have it after Bihu. Demotion, promotion, what is the problem? Hmm? In view of the above and on the request of learned counsel for both the sides, registry will list this case on 20th of April 2024 as a fixed item. This writ petition, an attempt would be made to dispose of the writ petition at the stage of admission hearing, parties to come prepared.
Item 28.
Petitioner, paid for this rule court, seeking the direction, conditional rule court regarding his after selection as a by the DLC for the post of grade 4 compassionate grant in the year 2012 SLC also considered but subsequently government issued one notification wherein it is stated that all of those pending cases of the compassionate grant can be considered. In view of this notification, some of the candidates, those who were selected, rejected along with me in the year 2015-17, were given that appointment letter in the year 2021.
So father died on 16/1/2012.
Yes, yes, madam.
And when was the application submitted?
It was in time. I want to place first time, DLC, what DLC considered, selected. It was the next page 16, Annexer 1.
No, I'm not asking the page number.
Yes,
I'm saying when was the application filed?
Yes, application was filed, as it is evident. Submitted April 31/12/2003.
31/12/2003.
Sorry, 2000. It is. Sorry, six. I don't.
69.
9/2/2012. Sorry. 9/2012. 9/2/2012. Page 16. It is there.
The application was submitted on 9/2/2012.
In time.
And then he was recommended by the state level committee or district level
District level, madam.
on 18/2/2012.
Yes, madam.
But the SLC did not approve his candidature.
Yes.
But when was the SLC's decision taken?
First time, it was in the year 2015.
Hmm.
15, it was rejected. 17 also, his candidature was considered, but it was rejected. And subsequently, two candidates along with them were already considered in the year 2021.
Hmm.
And because, there is a government notification they have published saying that those are the all pending cases prior to 31/3/17 that has to be considered.
So your case has been considered.
Earlier that was considered, but those are the pending cases. Even after rejection, also that can be considered.
Correct. So this time also SLC has considered your case.
No, my lord. In 2021, not considered.
So what is the order you are seeking?
I'm seeking for consideration of the same, in the next SLC meeting. In view of this government
The
notification.
instructions are not there, but it has been rejected on, I think one of the first thing that has happened is that, Your Lordship, in 2012, the notification said if there's one single vacancy, you can also consider for compassionate appointment. So that is why he was considered. But then when the SLC considered in 2015, the
So
notification.
in
changed.
2015, when his candidature was rejected, did you challenge it?
No.
Then what can be done now?
2017, it was again rejected. 2017, it was again rejected on the same ground that spent his force times.
So today, how can we ask them to consider again?
Because in view of this government notification, again, it may be.
Where is the notification?
Last page, madam, next 8. Let us start from page 34, madam. It was Joint Secretary wrote to the madam, director of the department, madam. In inviting a reference to the above, it is informed that the Honorable Chief Minister of the Assam has desired that all the pending compassionate ground appointment cases prior to 2017 shall be finalized within 3 months. Paragraph so and so. It is further to be mentioned that the compassionate family pension scheme has been introduced by the government of Assam in Finance Department notification dated so and so. In lieu of the compassionate appointment which is applicable to those employees who died in harness on or after 1/4/17. However, it has been observed that many proposals for compassionate appointment in various departments are still pending for disposal for the cases where applicants' relative had died on or before 31/3/17, which are to be disposed under the provision and guidelines issued by the Personnel B Department dated 1/6/15. In view of the above, I am directed to request you kindly to furnish the present status of the proposal. It was published by the Commissioner Secretary Government of the Personnel B Department.
So you want the benefit of this notification?
Yes, my lord.
But
And one of-
there is nothing in this. They have only called for status, that's all.
Status, my lord. But in view of this, another candidate, my lord, along with me, who was rejected, Nirav Sudhiri, here, this case was pending before this honorable court. He has been already recently considered.
And appointed.
No, my lord, he has been considered. I have heard that he has been considered. That's why, my lord, Nirav Sudhiri.
Some specific information.
So where is that order? Where
I have
is-
not found it. I'll bring that, my lord. Then Friday, my lord, Friday.
Mr. H. Das, Learned Counsel for the petitioner, prays for his granted 3 weeks' time to bring on record documentary evidence to show that another similarly situated candidate has been considered for appointment on compassionate ground, despite the similar delay despite similar nature of delay in his case as well. Mr. C.S. Havikal and Government Advocate Assam to also obtain instruction. Let the matter be listed accordingly.
Or date, after 3 weeks.
20th of April.
20, Your Lordship.
I will ask you.
I can 29 and 30.
May I please? My lord, the petitioners before my lord are working on various posts in Krishi Vigyan Kendras. My lord, these Krishi Vigyan Kendras have been introduced in India by under the aegis of the Indian Council of Agriculture Research.
Yes.
Under the Indian Council of Agriculture Research, the council is not there who has filed the affidavit. There is a council appearing for it. But here what had happened, my lord, all over India, they have a particular scale of pay and allowances. In northeastern region, 2 allowances are added, SDA and SC. Now everybody is getting it. Only the persons under the KVKs of Assam Agriculture University, they have stopped. And the only reason for stopping is some organization had made a letter. Why are you giving it to them? That much only, madam. They have filed an affidavit. Unfortunately, she is not there today.
Who's the council?
Lady Madam Jupiter Das, no? Yes. No point, madam. No.
What to do?
My lord, otherwise pleadings are complete. My lord can have it for a
We'll have it after 2 weeks and then if she's
lordship.
not present, then.
Lordship.
All right, Mr. You can have senior counsel listed and so a query for the. Your name, please?
L Das, my lord.
Well, that's appearing for the writ petitioner. Mr. CS, you are there? No.
No.
However, the learned counsel for the respondents is absent, although the name is shown in the cause list. Full stop. Since a decision on the controversy raised in the petition cannot be taken without hearing the respondents' counsel, hence this court is not left with no option but to adjourn the matter for 3 weeks. It is however made clear that if the respondents' counsel remains absent even on the next day, the matter will be taken up on the basis of materials available on record.
Much obliged.
Make it 4 weeks then.
4 weeks.
Yes.
Item 31.
Here, your lordship, records are awaited. Last occasion, records were called for. We have filed affidavit, but records are awaited. Some more time will be given. Immediately after Holy. Immediately after Holy.
I had Mr. S. K. Goswami, learned counsel to the petitioner, also for Mr. D. Bora, learned government advocate also, appearing for the state who submits that the records as called for are still awaited. And therefore, this matter will be listed again after 2 weeks. Mr. A. Chaudhary, learned counsel is present on the
Number 5.
number 5. Please do. On the request of learned government advocate, let this matter be listed again on 15th of March 2023. So as to enable him to produce the obtain the records.
Obliged. Only thing is, Lordship may remember, this is selection at a post of administrative officer in the Deputy Commissioner Office, Pascal.
Lordship, in this matter, Lordship, I'm appearing for the GAD. On the last occasion, Lordship has asked me to bring the records. Accordingly, I have made got the records as well as the chart. I have made it.
They have sent it to them.
My lord, I have gotten. We are appearing.
Okay. So we'll have it on 15th March.
Lordship, only thing is, Lordship, ACR is not a secret document, it's a personal document of the petitioner, Lordship. When we inspect the ACR.
Lordship, that won't be required. I've already made a chart and I'll produce it before the court on that day so that my lord, we
Let us see,
can
then.
navigate.
I can
through
see,
the-
Lordship, it is my document.
We can
Lordship.
navigate through it. my
We'll
lord.
wait till 15th. We'll. Okay. All right.
Please, please, please.
Item 32.
I'm not for-
But here, the state level committee rejected the petitioner's case, madam, only on the ground that the ground assigned mallet by the SLC was that non-availability of vacancies as per roster register. Lordship will find the page at page 38, relevant portion, 39 mallet.
Just a minute, just a minute. So you have come after 6 years, 8 months.
That was that is there, but in the meantime, when I have come to know about the fact of rejection in the office of the this director, then only it has come to my knowledge, my lord. Then to that extent, my lord, we have the division bench judgment, my lord, this saying that this cannot be attributed, my lord, in consideration of the petitioner, my lord. That we have the
So your case was rejected by the SLC.
SH.
What is wrong with the rejection?
Rejection is my here, since on the basis of this, the reason which has been assigned, my lord, there is non-availability of vacancies as per roster register. Since, my lord, this petitioner's case was considered by the DLC after considering all these aspects. And accordingly, my lord, the post was also shown thereof. And against that post, my lord, he has been, his case has been considered and forwarded by the DLC, my lord, after due approval, my lord. Now SLC has contradicting the DLCs without having any reasons, simply saying that randomly this order has been, the person's name have been my lord, here mentioned here, whereas other persons who have been rejected on the same ground, they approached before this honorable court and their cases have been considered by this honorable court also. Similar cases I have also
Where
approached.
where is the order?
This order, my lord, lordship will find at page 14, my lord, sorry, 51 and 52, my lord. 51, 52, and 53, my lord. His name was also rejected on the same ground. This person. And the division bench also said on the same ground, my lord, it has been said. The lordship will look into the matter of division bench of this honorable court. Para 4 and 5, my lord.
Yes, if the DLC is recommended, then why SLC found that no vacancy was there? Was the DLC wrong?
Lordship, as per the office memorandum, it is stated that there's lots of, it is spent there force, Lordship. It is expired on 2 years, Lordship.
Where is the resolution of the SLC?
SLC resolutions,
Page number?
principal 10, Lordship.
Sorry, page number?
Page number 47. 47.
And which part relates to the petitioner?
Principal 10. If the principle of application of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application will require no further consideration and must be understood to have spent their force.
No, you see, DLC had recommended his case. Then at that time vacancy was there.
That's a vacancy.
What happened to
there.
that vacancy?
There is a vacancy, Lordship, at that time. DLC.
What happened to that vacancy?
Now, after that, it is filled up, Lordship. In the 2000, DLC recommended in the year 2000.
You are making a guess or you have the instruction?
No, Lordship. The DLC recommended a meeting of 19/8/15, Lordship.
You got instruction?
No, Lordship.
Then on what basis are you making?
On the
this
basis of WTC Lordship.
On the basis of his case.
His case Lordship. He had to receive any instruction Lordship.
These matters are absolutely this shady and then passing orders, consider again. It's not going to, unless there's clarity on what is happening. What
Lordship,
exactly has happened? Huh?
2008-15 SCC 560 Apex Court stated that Lordship appointment of compensation cannot be claimed as a matter of right, that it is a concession, it is not a right. Clearly stated that.
That is all
Lordship.
right. So he's saying somebody else approached the court and then his case was.
He has come Lordship after around 5 and 6 and a half, 8 months Lordship. 6 years, 8 months they come Lordship.
You find out and tell us what has happened. When his case was recommended by DLC, there was a vacancy. Then after that, why it was rejected? You have to tell us that. When will you tell us? At 2? Huh?
Day after tomorrow. Day after tomorrow.
Next week.
Next.
Let him get the instruction. Part Mr. B. Chetri and counsel for the petitioner also for Mr. H. Chetri. Government advocate Assam appearing for the
2 and 4.
2 and 4 and Miss M. Chaudhary. Huh? MM Kotokri. Then a counsel for respond numbers
1, 3 and 5.
1, 3,
1,
5. Okay. On the request of Leonard Department Council, this matter is directed to be posted again in the next week, so as to enable them to obtain instruction and appraise this court as to why the SLC had rejected the application of the petitioner despite the recommendation made by the DLC indicating that vacancy was available at that point of time.
That affidavit they have filed, my lord, respondent number 1, 2, 3, and 5 already filed the affidavit. It is in our record, my lord. And they did not say about all these things, what he raised the question, my lord, now.
No.
And out of readings, how can he flee all these things, my lord?
Not affidavit doesn't have, not
Affidavit filed by
Not
1,
filed.
3 and 5.
Affidavit affidavit in opposition filed on behalf of the respondent number 1, 2, 3, and 5. This is the affidavit. I do not know. From the record, I'm reading, my lord.
No, it's your-
Now, if they make the different, please, my lord, now.
All right, you check out.
No,
Let
no.
them-
Affidavit has not been filed.
No, whatever has to say, my lord, it should be transparent before this honorable court.
Item 33.
May it please your lordship. So this matter regarding the promotion from the post of grade 4.
Depends on.
No, 34. From the post of grade 4 to the post of junior assistant manager. And the petitioner initially was appointed in the year 1992, manager. And thereafter he was brought on regular status in the year 2000.
Which is the department?
My department not yet filed any affidavit, manager.
No, but which is the department?
Manager, department PWD.
Yes, who is appearing for PWD?
My senior Rahul Dhar.
Where is
He's
he?
on next. Kindly pass on for the matter for time being.
Pass over for time. Call him.
Much.
Item 34.
May I please one?
Yes.
My lord, the petitioner with my lord is a professor with the OKED, my lord. It's called the Omio Kumar the Institute of Change and Development. It's an autonomous institution created by the government of India and my lord, the central government, ICSSR. Now, what had happened here, my lord? Everything that is being followed here is the UGC norms. The department, the board of directors have also decided that the service condition also will be governed by the board, the UGC norms. If it is the UGC norms, then the retirement age of professors is 65. The government of Assam has taken a policy decision for all colleges, educational institutions, professor 65, including medical colleges. Now that decision is not being applied here. They are every time saying we are reviewing it, we are reviewing it, all meetings because of big board.
Who has said they are reviewing it?
My lord, everywhere, my lord.
This is a private or a government institution?
It's a government, it's a government institution. My lord would come to page 133, madam. This
Yes,
is a,
who is appearing for the respondent?
they have not filed an affidavit.
So Lordship, we have received I am appearing for respondent numbers 1, 2, and 3, the Transformation Development Department. We have received the pairwise comments. Some time will be granted to file the affidavit here, Lordship.
Otherwise, normally, now what is his date of retirement?
No, there is time, but until February, next February, I'll be retiring, madam.
Let them file the.
Lordship, that's what I want, but let it be decided, madam.
What about 4, 5, and 4 to 7? You would like to file affidavit? All right, take down hard, Mr. Yukinal, and senior counsel is by Mr. T. Chakraborty, and counsel appearing for the writ petitioner. Mr. D. Bora, learned government advocate Assam, appearing for the respondent numbers 1, 2, and 3, submits that he has received pairwise comments and therefore be granted 4 weeks time to file affidavit. Ms. R. Devi, Learned CGC is present on behalf of the respondent number 5. 4, whereas Ms. M. Devi has appeared for respondent numbers 5 to 7. Full stop. On the prayer of learned counsel for the respondents, this matter stands adjourned for 4 weeks so as to enable them to file affidavit. You file your affidavit or increase the age. Which option
My
looks
friend
better?
says that they are agreeable to that 65. That if it comes on record, madam, that will
According
be-
to us, as per the pairwise
You
comment.
add one more thing. Since there is no dispute, there is no wrangle at the bar that the age of teaching professionals,
Professor.
the retirement age of professor across the board has been enhanced to 65 years
By the government of Assam.
by the government of Assam. Hence, the learned government advocate to obtain specific instruction as to why the same criteria cannot be applied in case of petitioner, who is also similarly situated as a professor under any other government.
University system. madam.
No,
In the university system.
No, your lordship, here, as per it says that OK, DICSD is not under purview of the education department, so they will have to actually see. So they are not under.
And a counsel for the respondents to obtain instruction as to why the same criteria cannot be applied even in case of the writ petitioner, who is also working as a professor in an institution coming under the government of Assam.
Much okay.
May I proceed, please?
Yes.
Our petitioner applied for Anganwadi worker and perhaps.
Your lordship, instructions are awaited because we have sent it to the higher education department as to asking whether the Nagaland 12 board degree examination is recognized by the government of Assam. Now, the social welfare department doesn't have that notification. So we have sent it to the school education department. So that instruction is awaited.
Okay, select, there is an interim order.
Yes,
Yes, my lord.
How much time you want?
2 weeks time, your lordship. I'll again pursue.
Heard
with them.
Mr. N. Ahmed, learned counsel for the petitioner, Mr. D. Bora, learned government advocate Assam, prays for and is granted further 3 weeks time to obtain instruction. Interim order passed earlier to continue. They are allowed interim order passed earlier to continue.
Bless.
Time being matter item 33.
My lord, I have received instructions in this regard. I will file an affidavit though. My lord, the instruction, it's a small instruction, my lord. It says that, my lord, that this posts are personal, my lord. So there is no scope of promotion.
Which I heard Mr. R. Islam, learned counsel for the petitioner, also heard Mr. R. Dhaw, learned standing counsel, PWD department, Assam, who submit that he has received instruction in the matter. First of, according to the instruction received, the post held by the petitioner is personal to him, and therefore there is no scope of promotion. Mr. Dhar, however, prays for and is granted 3 weeks time to bring those facts on record in the form of an affidavit. Let the matter be listed again after 4 weeks. Supplementary release for admission item 55.
My lord, again a complex of the appointment. My lord, relating to PWD department.
Here also the petitioner is a long pending case, my lord, since 99, my lord. A long litigation, my lord. On 24, 1999, the father of the petitioner died. He applied on 31/7/99. Thereafter, a long litigation, my lord. Lordship may kindly see.
Mr. Bhattacharya, I must put you on notice. I remember there are some judgments authored by me where I have expressed the view that whatever be the ground, such delay will extinguish the claim. Perhaps I cannot take a different view in this matter. Would you like me to dispose it of today or adjourn it?
My lord,
Make up
there
your
is-
mind.
On which, but there is another aspect. My lord. I certainly go through your lordship judgment. My lord. There is another aspect, my lord. Very recently, this honorable court has set aside the ground on which this petition as unconstitutional, on which this petition is challenged. That is another ground, my lord. The leftover service is 3 years. That was set aside by this honorable court as unconstitutional. That way, this is.
Any appeal has been preferred against that judgment?
Not yet, Lordship.
Then
Lordship, we have an instruction, Lordship. It's of the department, Lordship, the PWD department, and the department is not placing it before SLC this time, Lordship. As per clause 24B, Lordship. The last part, Lordship.
so have you seen this?
No, I don't know. I copy has not been signed.
Have a look at this. Your name is Ramakrishna.
Ramkrishna, my lord.
So 3 times your case was considered and rejected. So no further scope to consider your case. That is the government's stand. Have a look at it.
It's as per 24B, Lordship, not as per the 3 years.
So you please examine it.
My lord, a copy may be furnished, my
Can you
lord.
give him a copy?
Lordship.
Right. Mr. D.N. Bhattacharya, National Counsel is present on the petitioner. Ms. A. Talukdar, Government Advocate Assam has produced a copy of the written instruction received by her, according to which the petitioner's case has been considered and rejected by the SLC on as many as 3 previous occasions. And therefore, in view of, what is this clause 24B
24B, Lordship.
of the
2015 OM, Lordship.
OM dated, what is the date? Give the date.
OM dated for
On that ground, it was not rejected. my lord.
OM dated 1st June 2015.
1/6/2015. His case cannot be considered afresh. Mr. Bhattacharya seeks some time to examine the matter and make further submissions. His petition is accordingly adjourned for 3 weeks. Just check up, you may find that judgment.
Can it date be given by? Long pending case, my lord.
These things are, we're sorry to say,
Lord, my lord.
you know what will happen. So you decide the date when you want it to happen. Question doesn't arise. Within 2 to 3 years, if the matter doesn't come to an end, whoever is at fault, it cannot be done. That judgment, time has come, that is to be.
The honorable.
No, it is going on,
Go
people
ahead.
dying in
Go
95,
ahead.
99, they are still coming for compassionate appointment.
My lord, 6th time this case has, this is the 6th
And he
time.
is surviving,
It is,
Lordship.
this case is before the
That's the
lordship.
problem, because he will immediately show this order, that order. But the question is, what is the law? Compassionate appointment, the very idea is to give immediate relief to the family members.
My lord, it is
The
the tide over
person
the
should be
situation.
qualified, eligible.
It is
not
the
qualified.
to tide over the.
If it is not there, it is not there.
No,
It's not a right.
Even then, some honorable court has directed the other institution a similar.
That is the problem.
That is the
You
problem.
first get an order and then come with that order.
Similar.
But I will pass an order only if it is in accordance with law. Not otherwise.
Deeply obliged, Lordship.
Yes.
Item 56 and 57.
My lord, we are yet to receive instructions in this regard, my lord. We have written to the department, my lord. Another 3 weeks, my lord, we will need, my lord, they say.
Lordship, I'm retiring on November, Lordship, this November, Lordship. 2 weeks is granted, Lordship. And the matter may fix on 15th here, Lordship.
What is the matter about?
Lordship, the first one is the penalty of censure, minor penalty of censure, and second is for promotion, Lordship.
Actually, we'll fix it on 21st. Yeah. You are
31st, Lordship, 31st.
Yes. 21st.
Lordship, I'm being led by an outsourcing council, so it can be taken on 31st.
31st March.
Yes, Your Lordship.
All right. You are Mr.
W. Sharma, Lordship.
Mr. W. Sharma, Learned Counsel for the petitioner is present. Mr. R. Dhar, Learned Standing Counsel, PWD Assam, prays for further 3 weeks time to obtain instruction and file affidavit. Mr. C.S. Hazarika, Learned Government Advocate Assam is present on behalf of respondent numbers 5 and 6. On the request of Learned Counsel for both the sides, let this matter be listed again on 31/3/2023 as a fixed item. The respondents may bring their stand on record in the form of affidavit on or before 28/3/2023.
In 2 cases, my respondent numbers for the state is different. So take for the state respondent.
For the state respondent, yes.
31 or 20.
For orders, item 36.
None appears for the petitioner on call matter stands adjourned for 4 weeks. Yes.
Item 37.
That is lordship. Service is complete, lordship. Respondent number 3 has submitted the affidavit. Matter may come up for admission. In the meantime, I will file my reply.
It is submitted to the bar that this matter is ready as regards service and therefore be listed for admission. Office to verify and list the matter in the appropriate column after 3 weeks. In the meantime, parties may exchange pleadings. Over to Mr. S. D. Purkayastha for petitioner and Ms. D. Bora, Learned Standing Counsel Health.
Health Department.
Obliged.
Item 38.
Have you received the money? Have you
I have received. I
You have
have
received.
Lordship.
So then what remains?
And other issues,
The issue regarding non-practicing allowance of the petitioner is, we have, the area salary part has been paid, my lords. Now, lordship, I have received some instructions where the department is saying that the non-practicing allowance was discontinued. That is why it might not be applicable on the petitioner. They have sought for some time to get the clarification regarding the non-practicing allowance, my lords. Area salary has been paid, my lords. So, lordship, I'll just, and the government has not been made a party, but I'm not getting into that, my lords. I'll get the instruction, but I'm just seeking 3 weeks time so that I can consider the case of the non-practicing allowance for the petitioner, my lords.
and about the interest part, Lordship.
Interest part was not mentioned in the order, my lords, but which he is seeking, my lords. That
No, Lordship, it was there in my representation.
In the
and they have given
representation.
reply. And in the last order, Lordship,
The other issues have to be replied to. And interest part, I want a reply, Lordship.
Lordship, that 3 weeks time may be granted, we'll come up with that reply also.
So you count 82 lakhs, you need to count, no, you need some time, 3 weeks, let him get the instruction.
Lordship, 3 weeks
The
we'll
other-
come up with.
Lordship, may I make a small supplement? Lordship, the Honorable Supreme Court had said that there can be no gainsaying the fact that the government which has delayed the payment of salaries and pensions should be directed to pay interest at an appropriate rate.
Lordship will satisfy your lordship.
Lordship, this is in relation to the case Dinavahi Lakshmi Kamesri versus government of Andhra Pradesh, where the order was given for paying interest.
All right, he is asking for a little
3
time
weeks.
because the government is examining, right?
3 weeks time.
Dr. Basanta Lashkar is present in person. The petitioner is present in person and has confirmed that he has received the sum of 82 lakhs 02,578 being the arrear of salary payable to him by the health department. First of, however, according to Dr. Lashkar, the amount of
Non-practicing allowance and.
non-practicing allowance and interest component has not yet been disbursed by the
That is under
authorities.
consideration, my lord.
First of, Mr. H. Aliya, learned counsel appearing for the
Both the contempt.
both for the respondents has submitted that these aspects are being examined by the department and certain clarification has been sought for. First of, as such, 3 weeks further time to give.
Fixed date, Lordship.
In view of the request made by Mr. Shalia, let this matter be listed again on 29th of March.
39.
My friend, Lordship, as per the last order, Lordship, today morning I have received a speaking order.
You are Mr.
RS Ronghang, Lordship.
So we'll close it.
Lordship, let me tell you.
We have considered my lordship, his appointment for consideration was passed by the Honorable Court in 2021. In 2021, there is no vacancy, only the driver vacancy was there. So he could not be appointed. In 2023, my lord, 33 vacancies are there. We have filed the affidavit stating that we will consider his case in 2023 appointment against the vacancy of 2022. We have filed the affidavit to that extent.
What remains then?
The court passed the order for consideration of his case for appointment on compassionate ground. We have considered it.
Mr. Your name, please?
RS Ronghang.
RS Ronghang, learned counsel for the petitioner submits that he has received a copy of the speaking order dated
Order dated 10 to 2023, Lordship.
10 to 2023.
Passed by the principal secretary.
Passed by the principal secretary,
Karbi Anglong.
Karbi Anglong
We
Autonomous
have stated that
Council,
we will consider.
wherein it has been stated that the case of the petitioner will be considered against the
Vacancy
vacancy
of 2022.
vacancy of 2022.
33 vacancies are there, 5% post.
Mr. J. Chutia, learned counsel for the respondents submit that there are 33 vacancies
My lord.
and therefore the order of this court will be duly complied with within a short time. Full stop. In view of the submissions made by learned counsel for both the sides and considering the reflection made in the speaking order dated 10 to 2023, this contempt case is hereby closed. All right. If you are aggrieved, then you come, then we'll direct personal appearance, no other way out. Yes, a copy of the speaking order dated 10 to 2023 be written in the record.
Item 40.
Same, Lord.
Same order. Speaking order date is also same. Same order.
Deeply operated.
41.
My pleasure, Lordship. Also, last occasion, you asked to take instruction, Lordship. So as far as we have received instruction, everything has been done in our part. We have written the treasury of the senior account officer has already submitted the treasury officer. Right now, the treasury officer is they said that if there is a communication, they have made any communication to us, but regarding status of payment of the DCRJ, Lordship. They don't say any communication whether the payment has been made or not.
As per the instruction, the amount will be lost around 1,52,000. We have received 61,000. 61,000 we have received. The remaining part we have not received, as per my instruction.
May I please a communication, Lordship?
When did you receive 61?
Lordship, it was last, around 10 days ago. 10 days.
10 days ago.
10 days ago. Exact date is not written, but 10 days.
So in the court order, has any amount been mentioned?
No, Lordship, it was also directed to calculate considering 6% interest. And if they fail to pay within time, Lordship, it will be 9%. So they have calculated as per 9%, Lordship, since they have failed. And it will be as per.
It arrives at, if 9% arrives at 89,515, your Lordship.
And how much have you paid?
He is stating that he paid around 61,000.
You sort that out, and otherwise we will have no.
Yes. 2 season time, maybe we will take instruction over there.
Mr. J. Kalita, learned counsel for the petitioner, submits that after the order was passed by this court, his client has received only rupees 61,000. Full stop. As such, there is a shortfall of the amount payable to the petitioner. Mr. Gogoi, learned counsel for the respondent. Respondent number?
For respondent number, Lordship.
R. Gogoi, learned counsel for the respondent number?
1, your Lordship.
1 and Mr. So for respondent number 3, have both prayed for 2 weeks' time to verify the facts and make further submission before the court. Prayer allowed.
Item 42.
Ma'am, please ask. My lord, this case relates to the, my lord, non-payment of the pension and other benefit, monetary benefit, my lord. Direction was given to do needful, my lord. Page 27 is the operative part. Page 27, my lord, paragraph 212.
What has happened?
Lordship, here I have some instruction, Lordship, this is coming for the first time, but the grievance of the petitioner, they sought for some opinion, my lords, that opinion has been given. So my lords, Lordship may grant us some time so that we can understand what process it is going on. The case of the petitioner is under consideration, my lords. It has come for the first time, Lordship.
One more thing, my lord, somebody has written a letter, my lord, in respect of some letter has been written, my lord, reflecting, my lord, filing of respondent number 1 and 2 or something like that, my lord. I cannot recall, my lord. So in that case, my lord, the service is complete, my lord, and let them come with the update what they have done. And they cannot write this type of letter, my lord, addressing.
How many respondents are there here?
Two, Lordship.
Direction was given to the.
You are appearing for whom?
Respondent number 2, Lordship.
And what about 1?
Lordship, I have not.
1 vocal number, causeless reflex, respondent number 1.
Mr. Jay Bonvia, learned counsel for the petitioner is present. Mr. A. Solia, learned counsel appearing for the respondent number 2, submits that the matter is under scrutiny at the level of the department, and therefore 3 weeks further time be granted to appraise this court as to the steps taken for implementation of the court order. In view of the request made by Mr. Chalia and considering the letter dated 2/12/2022 placed on record as flagged capital A within quotes capital A, registered to list the matter again after 3 weeks by reflecting the name of Miss D. Bora, Standing Counsel Health Department, Assam, in the cause list.
1 is also complete, my lord. Lordship fix the date, my lord. I'm retired.
Very compliant with it.
Any date, lordship, that is not required. So for notice is complete.
Item 43, 44, and 45.
How many more are there?
My lord, in item 43, I am appearing. Readings are complete, matter may be fixed for admission hearing.
What is this IA for?
My lord, what happened, we filed this writ petition because we are working as stenographer grade 2 and we are having graduation. And as per the service rules, graduation is required for promotion to the next higher court. This is scenario for grade 1. Now, my lord, what government tried to do, they tried to relax the recruitment condition of educational qualification, and some persons who are not having graduation, they have to be promoted and will file a petition, my lord. And the honorable court has granted us a stay. On the same date, my lord, they have issued a, my lord, notification for promoting them, but we are covered by the interim order passed by this honorable court. So this IA, my lord, it may be kept as it is, my lord.
It's in the, you are for the petitioner.
I am for the writ petitioner in item 43.
I am 44, my lord.
Mr. J. Patwari, learned counsel for the writ petitioner in item 43, and Mr.
A. Khoniko.
A. Khoniko, learned counsel for the petitioner in item 44, have submitted that the writ petitions are ready as regards pleadings and service, and therefore be posted for admission hearing. The learned departmental counsel, Sri A. Fukan, as well as Mr. M. Shah.
I am for the petitioners in item 45 and the respondents in item 44. So I'm.
Then we are similar is the stand of Mr. M. Sharma, learned counsel for the petitioners in item 45. Mr. A. Fukan, learned standing counsel, personnel department.
My lord, general administration.
Central
General administration.
General Administration Department submits that he has received the records and therefore is ready for admission hearing. On the request of learned counsel for all the sites, let this matter be listed for admission hearing again on 23rd of March 2023. The connected IA be kept pending and be listed along with the main writ petitions. Main writ petitions. Yes.
May I please your lordship, my lord, the office note shows that the service is complete on response number 12. And regarding 6 to 11, my lord, office note dated 9/1/2023, my lord.
Nine 1/2023.
Yes, my lord.
No, but 7/11, 7 to 11, it says is not complete.
Not complete. Yes, I'm saying, my lord.
So you have to take fresh steps.
Yes, my lord, probably we'll have to check because it shows that there is no postal record also, my lord.
Let him take Mr. P.P. Bora, learned counsel for the petitioners, has invited the attention of this court. Petitioner has invited the attention of this court to the office note dated 9/1/2023 to submit that since service of notice is not complete on respond numbers 7 to 12.
6 to 11, my lord.
6 to 11.
Yes, my lord.
6 to 11. He be granted leave to take fresh steps on the aforesaid respondents. Mr. P.K. Medhi, learned counsel for the respond numbers
1 to 5.
1 to
1
5
to 5 and 9, your lordship.
1 to 5 and 9
Yes, lordship.
is present.
Extra 9 will do.
Acha. In view of the above, the petitioner's counsel may take
5 and 9.
fresh steps for service of notice upon respond numbers 6 to 8 and 10 and 11
Yes.
by registered post. Let the matter be listed accordingly.
I don't also let the format.
Yes. This relates to seniority matter.
Service has not been completed with related to some of the respondents. There are a number of respondents. Was listed before law Jima. And so far as bringing the inspection, my lord, we need 4 weeks time to file my affidavit in opposition.
Acha, have you seen there is an order of 22 February?
Yes, sir. I contacted the law,
So you are to take fresh steps.
Your Honor, on 19/10/22, there was order that whatever, all are the employees of Food Corporation of India. All the respondents, notices will be sent to the Food Corporation of India Journal Office here in Guwahati. And they were supposed to accept it, but they have refused, they have not accepted, hence it was returned back. In
So
fact,
what to do now?
Some of the officers who were posted in journal office, they have accepted related to that, those officers. And remaining.
So what is to be done now? It's time.
Yes, Your Honor. I would request the Honorable
It
Court.
needs the address of those officers. I can provide it. I will tell my journal
So
officer.
you furnish fresh address, you furnish.
Lordship, may
Ah,
kindly-
Your Lordship, my request is that if the clear-cut instructions are given by through Honorable Counsel for the Food Corporation of
First,
India,
let him give the addresses to you.
I had personally contacted, they have not given me the
I
addresses.
will provide it.
I had
All right. You are Mr.
G.K. Gupta.
Mr. G.K. Gupta, learned counsel is present on behalf of the petitioner. Mr. V.K. Singh, learned standing counsel FCI is present on behalf of the official respondent.
1 and 2.
Official respondent numbers 1 and 2. Office note dated 22/2/2023. No, office note. Order of the Lwajima Court dated 22/2/2023 goes to show that several respondents are still unserved in this case. First up, Mr. Gupta submits that since those respondents are all employees of the FCI, hence an order be passed for service of notice upon them through the department.
Your Lordship, one more request is there. That whatever the written notices have come, is it consists of this
It is returned those petitions which has been written.
2,750 pages. So whatever the written notices are there, they may be handed over to me so that I can take.
Okay. Mr. Singh has assured this court that he would furnish the current address of the unserved respondents to Mr. Gupta within 2 weeks from today. Full stop. The request made by Mr. Gupta for return of petitions
Unserved petition.
on the unserved petitions which are lying with the registry. First up, his request is granted. Mr. Gupta may approach the registry by making appropriate application on that behalf. Release this case again after 4 weeks.
I got 50.
How many are there? Yes, what is
Yes, I
this?
have received the instructions, my lord. Sometime 3 weeks time may be given for.
And
filing.
yes, for the petitioner, Mr. H.K. Das, counsel for the respondent submits that he has received instruction and therefore be granted 3 weeks time to place the same on record in the form of an.
Look, there is a private respondent also that service is completed or not.
In the meantime, office to call for service report on restaurant number 6. Acha. Mr. C.S. Hazarika and counsel is present on behalf of respondent number 1. There are 2 to 5.
I got 61.
I appear for respondent number 1 to 8. I'm seeking 2 weeks time to file my.
Interim order be completed.
Mr. S. Banik, learned counsel for the petitioner is present. Mr. R. Dubey, learned counsel appearing to respond numbers 1 to 8. Please for 2 weeks time. To
File my affidavit.
to file affidavit.
I have received the instructions. I put the respondent number 10, my lord.
Mr.
Kumar.
V. Kumar, learned counsel for the respond number 10 also makes a similar prayer. In view of the above, let this rate petition be listed again after 3 weeks. Interim order passed by to continue. So anybody is ready for a part 2 hearing? Original? Right.